Justice at the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court, draw near to give their attendance, and they shall be heard.
Please be seated. The first case for oral argument this morning is People versus Jennifer Pryor.
Good morning. My name is Thomas Smith, and I appear on behalf of the defendant, Ms. Pryor. Jennifer Pryor is now 38 years old, still a mother of 5 children.
Yeah, Mr. Smith, can you just get right to your
Sure.
argument? Thanks.
Yeah, we challenge the conviction here as unlawful on several grounds. 2 erroneous evidentiary rulings by the trial judge caused the jury to...
What are those? What are the...
Number 1 was the trial court's failure to admit the entirety of a recorded video-audio recording of the police interrogation. That recording, the judge only allowed inculpatory portions of that to be admitted into evidence, and in so doing, didn't allow the defendant to show through the entire record that she did not ever, was not ever asked by the police officers to provide any detailed information about prior beatings and assaults committed by her husband, Roger, 14 of them or 13 of them over a 4-year period, including chokings, bitings, and other terrible events. In so doing, the jury was left with the prosecutor's contention that Jennifer Pryor had fabricated her recollection at trial of those terrible events, those 13 beatings. She had made it up, according to the prosecutor, and the jury, not allowed to see what she was asked at the
I think we have that.
at the trial. So that is crucial. That is crucial, and the Court of Appeals, in a variety of decisions, has upheld the right to get the full reading. The whole must stand or fall together, according to the Court of Appeals. The second evidentiary wrong involves the prosecutor's ability through the trial court to impeach Jennifer Pryor's credibility by omission, by pointing that out incorrectly, that she had been asked repeatedly, according to the prosecution, in those interrogations and in questioning by the police at the scene, to explain the history of prior beatings. She was never asked to do so. The evidence is crystal clear on that, despite the prosecution's conclusory claim that she was repeatedly asked. She wasn't. She was asked one question about that. Did you and your husband ever fight? And of course, the answer was yes. No particulars, though, Judge. And this court and the Court of Appeals have made repeatedly clear that you must be specifically asked about such prior events in order to be impeached when your trial testimony details those events. There was no fabrication here, but the inference, the argument that she fabricated highly influenced the jury, and I believe caused them to dismiss her claim of justification here. It must be shown that it was highly unnatural for her to have not explained in detail what she explained in detail at trial about the 13 beatings that she suffered over the 4-year period. And she's no expert in the law. and can't be held to have known that the significance of those details.
I think we understand that.
Okay. So that failure, the Bornhart case, the Williams case, make it clear it's highly prejudicial to impeach by silence. We also contend, Your Honor, that the evidence here was insufficient to...
You basically rely on an argument that the people failed to prove the absence of justification, right?
Correct.
Beyond a reasonable doubt.
Beyond a reasonable doubt, right. And we cite the case of Morgan, the People versus Morgan, First Department case of a few years ago, which in strikingly similar circumstances, a stabbing occurred during a fight between a domestic dispute between two individuals, and the person who was the defendant who stabbed her partner had been a victim of prior chokings and beatings in the past, and the court recognized...
But with respect to this particular evening, or this particular event, did you disagree that there was proof that the defendant was the aggressor?
Yes, yes. There's no proof that she was the aggressor, Your Honor, other than...
Other than a lot of witnesses indicating that throughout the course of the night, she was the aggressor.
Well, even so, there were witnesses that said absolutely not. Two witnesses. The prosecution relies heavily on...
So then it's a credibility determination for the jury.
Well, Your Honor, two witnesses. The prosecution relies heavily on what happened at Wendy's in a parking lot when Roger Pryor, drunken, .18, intoxicated. By the way, Jennifer,
First of all, pull
there's
up
no
your,
proof
please,
of her.
can you please pull up your mask so it's...
I'm sorry, I got it over my nose. No proof that Jennifer was ever intoxicated, despite what the prosecutor... I don't know how they came up with that.
She indicated that she had been drinking.
She had had sips of Hennessy. He
Well,
drank
she
a
said,
bottle.
at one point, she said she drank a bottle of
Oh,
liquor.
if she drank a bottle, Your Honor, she would have been drunk. And the police officer...
I'm telling you what she said. I'm not...
And then later, that same witness said, well, maybe she sipped from the bottle.
Well, look, it comes down to your client, there's no dispute your client stabbed the victim to death twice.
Correct.
No dispute about that. And her justification is based on her testimony that the victim was choking her to death.
Correct.
Or was choking her and she feared for her life. There's no evidence that he was choking her other than her testimony. And so it really came down to did the jury believe her? That she was being choked at the time.
No, there is evidence, Judge.
What evidence was it?
Professor Bachmeier from University of Indiana, who's an expert, a lawyer, a forensic nurse, expert on strangulations, has testified in 25 cases on behalf of the prosecution.
Wait a minute, but the expert didn't see this. The expert only said that some of her injuries could be consistent with that. The expert did not say that's what happened.
I disagree, Your Honor, with all due respect. She said, I examined the medical evidence and found telltale signs of strangulation.
Counsel, let's just assume for argument's sake that's correct. What I find troublesome is her testimony on how the event took place and the physical evidence that was ultimately determined, how the stab wound, the angle of the stab wound, the cut, the shirt, why the shirt was torn, where the blood was located in the car, all were, in my view, was inconsistent to where she said how it happened and what happened. So the jury had the physical evidence before it to consider whether or not what she said was true or whether or not what the physical evidence revealed. That's the way I looked at the testimony.
No, certainly the prosecution made those points about the blood evidence.
And so once again, as Justice Smith pointed out, the jury had to make a credibility determination based upon the testimony of your expert, based upon the physical evidence, and you're asking us to take a look at whether or not the justification should have been sufficient enough for us to...
And we will look at that very carefully.
Okay.
Do you have any other arguments?
And, yes, so the case of Morgan is but just to go back to that, Judge.
Well, no, I'm asking you to move on.
I'd like to answer Judge Lindley's question if I could, or address that if I might. Professor Bachmeyer from the University of Indiana, this expert, testified that she saw in the medical records evidence of petechiae, blood.
We understand
burst of
that, and they-
capillaries,
but she-
consistent with.
Yes, and that's what I said
How do
originally,
you deal
yes.
with the, and look, this is, you make a lot of good arguments, but let's assume that she was being choked. We have 2 stab wounds, one to the chest and one to the neck, if I'm not mistaken. Couldn't the jury conclude, well, maybe the first stab wound was justified, but it seems highly unlikely that somebody stabbed in the chest or the neck is going to continue assaulting her after that first stab wound, so perhaps they concluded the second one, I think both were fatal. Best case scenario, the first one may have been justified, but the second one wasn't. Wouldn't that be a reasonable way for the jury to look at it?
Well, the jury would be speculating on what happened inside a dark vehicle when she is testifying he is on top of her, choking her, and she reaches back and.
But once again, Counselor, I hate to point this out, but once again, what she said took place isn't consistent with the physical evidence.
I disagree.
I know you disagree,
I
but I mean,
disagree.
I'll tell you, that's my view of the physical evidence.
And that's how the jury could have viewed it. So that's why I'm asking you to move on. Do you have another argument?
Yeah, our final argument, Judge, goes to the sentencing. This mother of 5 who had no criminal record whatsoever prior to this was sentenced to 14 years, a determinate sentence and 5 years supervised. She has been in Bedford facility for almost 6 years now. Her children in Buffalo, 400 miles away. She was a feisty black woman who defended herself, certainly engaged in some activities with her husband that we can all say are inappropriate. But she had never been violent before, never caused any, never used a weapon, never caused. This was the first time in defending herself that she used a weapon, his knife. When we look at the purposes of punishment, I recall from my first year of law school, deterrence. Is she a threat to society? I suppose the only threat she is to if she has another lover who attacks her.
Didn't even the
inside a
judge, when he
vehicle.
was sentencing her, indicate that one of the things he was taking into consideration and the amount of time that she was incarcerated was the prior abuse. And how, in her life, and was trying to,
The judge took that?
pardon me?
I'm sorry, you're saying the trial judge took that
The
into
trial judge said that he took all that into consideration.
in giving her 14 years, it's hard to fathom that, Judge.
Okay,
And
well-
particularly in light of the Domestic Violence Survivors Act, which allows...
Couldn't she have received 25 years?
Of course, it was, that would be the maximum. Would that have been appropriate? Would that have been any more appropriate than the 14 years? No, of course not.
Okay, we'll look at that very carefully.
All right.
Good morning, Your Honor. Scott Miles on behalf of the people. As far as the evidentiary issues that arose at trial, the court weighed all of the factors and came to the correct conclusion. In regards to the defendant's statement to the police, the judge did allow the portions of the statements to police which were relevant to the questions that were brought out on cross-examination. He did allow that to come in on redirect examination. As far as the impeachment by omission, it's the people's position that the prosecutor did lay the appropriate foundation to impeach the defendant by her omissions. Turning to the weight of the evidence, as multiple justices pointed out here, this case came down to a credibility determination by the jury. The only evidence that the defendant was justified in stabbing her husband came through her testimony.
What about the medical evidence Mr. Smith referred to with respect to the strangulation?
Your Honor-
Telltale signs of strangulation.
Yes, Your Honor. The defense's expert witness did not examine the defendant that night. She relied on medical records. The doctors and nurses who did examine the defendant that night testified that they saw no signs of strangulation. The expert witness testified, I believe, the primary indications that she testified to that she saw of strangulation were the burst blood vessels in the defendant's eye. However, she also testified in cross-examination that those injuries are also consistent with being struck in the face, which multiple witnesses testified.
She was kicked in Wendy's.
Correct, yes.
But were there any finger marks, hand marks on her neck when she was examined by the police?
I believe multiple medical witnesses and police witnesses testified that they did not see any marks on her neck. There were some scratches. The defendant did have injuries that night. She had bruises, she had scratches.
To her neck?
I
thought there was some minor indication that there were some marks on her neck. Not, you couldn't see finger marks or anything, but.
I believe she may have had some scratches, but again, the defendant, there were witnesses who testified that the defendant was knocked to the ground at one point and kicked. So even with testimony that there were some scratches or injuries to the neck, it comes down to a credibility determination. And it
In
cannot.
essence, your point is that the physical evidence, both in the medical people that saw her, as well as the physical evidence at the scene, as I think Justice Centra pointed out, doesn't seem to support her version of the event.
Exactly, Your Honor. At best, at the very best you could say, is that there is ambiguous evidence.
And then it's up to the jury.
Correct, Your Honor, exactly.
Make
It's
credibility
the,
determination.
this
What do you
is,
say about the sentence?
the defendant, the defendant did not have a criminal record, that is clear. But the trial judge sentenced the defendant to the middle of the range that was available under the law. And it cannot be said, given the nature of the crime, that was a harsh and excessive sentence. The judge's statements at sentencing make it clear that he took various factors into account in coming up with that sentence, and it's the people's position that it was an appropriate sentence. Unless there are any other questions?
Thank you. People versus Sayo Barzi.
Good morning, Your Honors. May it please the Court.
Good morning, Mr. Altra.
Phil Rothschild from Hiscock Legal Aid on behalf of Mr. Barzee. The plea in this case was not knowing, voluntary, and intelligent. The law is very clear that pleas may not be induced by threats of a heavier sentence if defendant decides to proceed to trial.
You agree, you've conceded the contention's not preserved, right?
Absolutely, Your Honor.
Why should we reach it?
Well, the contention was not preserved in Fanini. Contention was not preserved in Boyd. The contention has not been preserved in a number of cases. However, the nature of the statements that this court and the Court of Appeals have found improper basically means that no preservation is required just because of what was said and done. This court has ruled over and over again. And here the statements were that he would probably be sentenced into the next millennia and that he would never see the light of day again.
Yeah,
Hey,
the
look,
statements, oh, go ahead. The statements were, I'll agree with you, ill-advised. But the plea here happened months later.
The
So
plea here
when I look
happened
at-
6 weeks later, Your Honor.
Oh, I
believe.
thought it was several months.
I think the statement was April 2nd. I think the plea was May 23rd, somewhere around there.
Okay. So I guess is there any indication in the record that those comments by the court had any impact on the defendant's decision?
Your Honor, I know that there's no indication in the record that there was ever any discussion to alleviate the impact of those comments. And I do know that what was said in this case has been found improper. Additionally, opposing counsel refers to this as hyperbole. I don't know when it is okay for judges
You
to...
look, there's no question. I have, this is one of the most coercive pleas I've ever seen. I've never seen a judge besides this particular judge is retired, ever say you're never going to see the light of day if you're convicted after trial?
You didn't see Judge Cunningham, but
Okay. Aside from him. But your client didn't move, so we have to decide. He didn't move to withdraw his plea on that ground or vacate the judgment on that ground. So we have to decide whether to reach this in the furtherance of justice. And you're right, we usually do, on less coercive statements. But here, your client got 8 years. He's already served the 8. He violated PRS. He's back in. He just had a parole hearing this month, I think. It's only going to get worse for him if we grant this relief. He is, now the judge did go overboard, but he's facing consecutive time on a number of different crimes that would equal a whole lot more than what he got. And he's already served his 8 years. So does that call out for us to vacate the plea? That's where I am here.
well, as far as his service of the sentence, I don't want to get into attorney-client discussions regarding that. But I think that it does, Your Honor, just basically for the legitimacy of the court and the legitimacy of the pleas. As you indicated, this is one of the most coercive. I would also note that not only was it hyperbole, but it was also wrong. Because essentially, the implicit in the judge's statements was, you're going to be sentenced to life. That ignores the fact that there's a 40-year cap by statute.
And it also ignores that it doesn't have to be consecutive.
Yes.
It could well be consecutive, and he probably deserved consecutive, but it didn't have to be.
Additionally,
It
Your
wasn't
Honor.
mandatory.
So I would note, based upon the nature of the threats that were made here, we would ask this court to, in fact, use its interest of justice discretion and reverse the conviction. Thank you.
Thank you.
Morning, Your Honors, Brett Oster for the people. I would obviously recognize that the court's language was ill-advised. With any luck, I'll be on the bench someday. I will make a note not to use that type of language. That being said, I think Justice Perdomo pointed out one of the things that's, I think, somewhat critical here. There was about a month and a half of time, 6-7 weeks, something like that, between those statements and when he actually pleaded guilty. In that period of time, he had two additional attorneys assigned. He had 2 additional pretrial conferences. Not much occurred on the record at those, but there was a significant amount of time, and he certainly had discussions with a new attorney about his prospects at trial versus the people's offer. Given that this is unpreserved, I think the sort of attenuation, this cooling off period, the fact that the judge just prior to some of the ill-advised words was expressing a very reasonable, if not lenient, thought in terms of what he would be willing to sentence as far as a negotiated deal. I think that sort of undercuts to the extent that it was coercive, it undercuts the coercive nature of the judge's words. We would also be somewhat ignoring that when the defendant pleaded guilty, he himself said no statements have been made to me to convince me to take this other than what's been put on the record. And I think that, if the defendant really felt, if any defendant feels actually coerced by the court or their attorney or whatever the circumstances may be, they should speak up, and we should give the defendant's affirmation that he was not unduly influenced here some level of credit. Unless there's any other questions. All right.
Thank you. People versus Nat L. Jones.
May it please the court, counsel, Timothy Davis on behalf of Mr. Nat Lee Jones. In determining whether a defendant has been denied due process on the basis of lengthy pre-indictment delay, there are 5 factors that have to be considered: the extent of the delay, the reason for the delay, the nature of the underlying charge, whether there's been an extensive period of pretrial incarceration, and whether there's any indication the defense has been prejudiced by the delay.
And now, there's no dispute that this is a long period of time before he actually gets arrested on this. But why don't you go through, if you would, what you think could have been done in the meantime? I mean, they didn't have this information for years and years, and then they had to go through it and, you know, do all this stuff.
Well, the problem is that the burden is on the people to show a reasonable basis for the delay. And looking at, there's really two periods, ignoring from 1980 to 1986, because there's clearly nothing done at that point. From 1986 to 2006, we have a number of things that are done, and the people simply did not call the officers who could have testified to whether this is simply neglect and trifling, or whether they simply met a dead end as far as investigation.
Would you agree that without the DNA evidence, when the CODIS hit was in January 2006, prior to that, there was not enough evidence to get a conviction, maybe not even an indictment, prior to the DNA evidence being obtained? Would you agree with that? If they just went with modus operandi, similar crimes, he was out of prison during the time, that wouldn't withstand a motion to dismiss, would it?
Well, the problem is, we simply don't know, because the witnesses who could have been called, this investigator Borriello, as well as the police officers who are referred to on the DNA reports from the lab, weren't called. So we simply don't know what they had and what they didn't have. And that's why the people failed to meet their burden. If all there is what's in the police report, then obviously then there is an issue. But one problem is that one individual who was not called was this investigator Boccaccino, who apparently was involved in the original investigation and kept his own notes as to similar crimes allegedly committed by Mr. Jones. And the people don't even know about this until 2012, when investigator Dominic is going through for Molyneux evidence and is showing, reviewing what are the like crimes. So I would say we simply don't know. If the police reports are all that there was, and we know there wasn't, then there wasn't. Now the one issue that we have that shows that there's a real problem, the fact that the people did not meet their burden, is Ms. Conklin, who testified from the lab. Investigator Dominic and Investigator Siersma and Ms. Conklin had said that from 1980 until 2006, this was a no suspect case. But we know from the reports prepared by the lab as early as 2001, when Marcia Bledsoe did the first test to see if DNA testing was possible, that on that report she wrote that Mr. Jones was the suspect. Then 6 years later, when Ms. Conklin does the report that shows that there is DNA that can be analyzed, she writes on the report that Natalie Jones is in fact the defendant. And this all happens before the CODIS hit. So we simply don't know, I would submit, what they had and what they didn't have from 1986 until 2006.
Counsel, address for me the time period of April 08 to June of 12, that time frame.
You mean from 2006 to 2012?
Yeah, excuse me, 2006, 2012.
Right. Well, there can be no question that as of December of 2007, the people had sufficient evidence not only to indict, but the evidence was close to overwhelming at this point. Now, what happened between 2006 and 2012 are, interviews off and on. In fact, the 65-month period that you're referring to, the investigator only spent 9 months of that 65 months investigating the case. So what we have, December of 2007, we know that the people had no more evidence from then until what they indicted in June of 2012. Investigator Dominic was asked specifically, did you have anything more in 2012? And he said, no.
Well, they had Tina Jones, the defendant's sister, who I think they talked to her in 2007.
That's right.
And
So they
she said he lived right behind or right next to where the victim resided. That was new, wasn't it? New incriminating evidence?
No, they had that in December of 2007.
Yeah, that's what I'm saying, in 2007.
Right. That's right. So in 2007, December of 2007, they have the DNA, they have Ms. Jones, who said that Mr. Jones was actually living at the apartment directly behind the decedent. And they also had then all of the incriminating circumstantial evidence with regard to the Northeast Rapist investigation, as well as all the information about Mr. Jones not being in custody when these crimes were occurred. So the people, there is absolutely no reason on the record, no good faith basis for why there's no indictment in December of 2007 and why there's a wait until June of 2012. Nothing.
Right, that's your best argument. Those 4 or 5 year period at the end is your strongest argument.
That's true.
As you go back in time, it gets weaker and weaker.
Yes.
And the question is, how many years is enough here? Your client doesn't seem to be prejudiced. He was incarcerated on another matter. So those are all factors, but you do make some good points with respect to the last 4 or 5 years.
Yeah, those are a lot of years. We don't disagree, and we'll look at it really carefully. We already have, but we'll go back and look at it again, all those time periods.
Thank you.
Thank you.
Good morning, Your Honors. Derek Harnsberger on behalf of the people. May it please the court. As Justice Smith and Justice Lindley both astutely observed, this is a case where clearly from the original act to indictment is a very lengthy period of time. But the reality is that until the DNA got to a point in which it could separate the materials in 2005, this was an unprovable case. While investigators suspected that an individual of this defendant's vile nature had committed the crime, there just simply wasn't anything, given the nature of the circumstances, that pointed to this particular individual until that DNA came up, reignited the investigation, and the investigation continued. So while we're talking about suspect, I think that's being used by the investigators as a term of art, where they suspected this individual could have been involved, but in terms of whether or not they had this individual with evidence.
The MO alone makes him a suspect.
Absolutely.
Doesn't mean you can get an indictment or.
Precisely, and this goes to Justice Lindley's point, is this would not have survived grand jury, much less would have survived trial, based on the nature of the evidence available, absent the DNA. We have an individual.
What about, once again, 06 to 12? Doesn't appear that anything really changed in pretty much in those 6-year period, 5-year period.
So in 2006, we have the DNA hit, and then we have the continued investigation into the defendant. At that point, one of the big concerns which was brought up during the hearing was the evidence purge that happened in 1988. One of the wild cards of this case that was never really explained was in 1988, effectively all of the evidence for this case was purged by the Rochester Police Department.
Purge, you mean it was thrown out?
The term that was used.
And it sounds like what happened was the year before that, Mr. Jones was given 25 to life for all these other rapes. He was the Northeast Rapist, I guess is what they called him.
Correct.
And perhaps what had happened there, it looks like, is since he was doing a life term, nobody anticipated further developments in scientific evidence. So it's like, well, he's got life anyways. We don't have enough now, so they threw it out. That sounds like what happened.
And it's a very reasonable interpretation of the evidence. And that's where from 1988, so investigations moving forward, this was particularly unique in light of the fact that you didn't have the original crime scene evidence that was available, and you had the very limited witnesses who are inherently available. So when they're conducting this investigation in 2005, 2006, 2008, that's part of the reason why the record reflects that the DA instructed the investigators to re-interview the defendant, which occurred in 2008. And part of that was to confront him with the new DNA evidence. Part of that was to confront him with the evidence that they've uncovered with Tina Jones, particularly that he was in the immediate area right behind the home. So there was reasons in 2008 why they re-interviewed him. During the hearing, one of the considerations for why they waited from 2008 until 2011 was parole. It's the people's contention that the parole determination was something that was of particular interest to this case. The defendant submitted multiple letters to the district attorney's office, to the investigators, to the police, where he engaged in lengthy, rambling narratives. He believed that he was the victim of an ongoing and continuous conspiracy by the Department of Corrections, prosecutors, investigators. So if there was ever an individual who may go before a parole board, this was his first parole appearance, and make inculpatory admissions as a part of trying to explain his conspiracy. This is that defendant. And it's also worth noting that this defendant was doing a life sentence. He's been doing a life sentence since the 1980s.
So when, in your view, was the earliest date that the people could have indicted?
I believe pretty much this fact pattern, Your Honor. In December 2011 was when the defendant was denied parole, and he went before the parole board. From December, the record reflects that the investigators lined up the witnesses, and then it was presented to the grand jury by June. I think if they could
couldn't line up those witnesses before, like in 2008?
You couldn't have gotten the opportunity to have him go before the parole board.
Right, see, but the evidence was the same after the parole hearing, because he did not admit, shockingly, a man who claims that he was wrongfully convicted and was a victim of a conspiracy, he did not confess to the murder at the parole hearing, which seems like what the theory is for waiting. Well, maybe he'll admit it. So the evidence they indicted him on was the same evidence that they had years before, 3 years before or so. And the reason they didn't proceed with the indictment then is they wanted to wait till December of 2011, I think, was his parole hearing, to see if he might cough it up voluntarily. That doesn't.
Well,
seem
we'll
like-
look at
Unfortunately, we don't know in 2008 what he's going to say or not say between 2008 and
Right.
2011
We
as a passage
understand
of
that,
time.
and we're going to go through, as I indicated, we're going to go through this again. We've gone through the time periods, but it's a very interesting issue.
And to that end, Your Honor, I would just close by noting there's no prejudice to the defendant in those 3 years. While there is a delay there, the reality is this defendant concedes that there's absolutely no prejudice at all
Probably
during
helped
that.
him, right?
Excuse me.
It probably benefited him.
If anything, this is one of those cases where time only goes to benefit the defendant. Correct.
Thank you.
Thank you.
People versus Lewis Bush.
Good morning. May it please the court, Brad Keem for the defendant appellant in this matter. There are a couple issues I'd like to discuss today. First, the conviction was not supported by the weight of the evidence. The teenage shooters did not testify and did not provide a connection with the 27-year-old appellant, let alone a community of purpose with the appellant.
Well, first of all, so you're dealing obviously on weight because of the legality wasn't preserved. Well, and it's interesting on this case, the most damning evidence is the video.
Correct.
It was amazing to see the car pull in, what the defendant's car did, how he did it, when he rounded the corner, never put it in park, 3 people run out of the vehicle, run across the street, multiple shots fired, run back in the vehicle, and I've never seen this happen before. A police car rounds the corner at the same time the shooting took place, and they didn't move 1 foot.
Some rough timing for sure, but we're still left with just that video. We're left with the shooters not testifying, the victim not testifying, no weapons matching appellant, and I think there's still speculation that's necessary when reviewing that video.
Right. When we say speculation, that's another word for circumstantial evidence in a lot of cases.
Yeah, perhaps circumstantial evidence, but again, this is a weight argument, so when looking at the weight of that circumstantial evidence, I think the absence of the other evidence demonstrated that the verdict was contrary to the weight. I'd also like to talk about the conflict. Defense counsel Stenoff represented appellant and the victim, Ortiz, on a concurrent parole matter.
You know, counsel, it's an interesting issue, and I looked at it closely, and it appears here that Attorney Stenoff was assigned post-conviction. So we're looking at that period.
Correct.
And then, but it appears, I'm looking at the record, even the statements being made, I can't glean from the record whether or not it was past tense or presently. It appears that it may have been past tense, that he had represented the victim in the past tense, not a parole violation.
I would agree that the record isn't clear, but I think because the record also indicates there was a 2 weeks after, during the trial was going on, he was picked up on a weapons charge, that parole that defense counsel Stenoff was representing him on would have gone through all the way. I think there's an inference that could be made on that. And I think that, as the court's aware, the 330 motion by defense counsel Steniff, I mean, it includes some salacious allegations, but I still think that appellant should have been aware that there was a danger that Steniff would have had to cross or examine his client or his prior client at that hearing. Finally, I'd like to talk about the sentence. Appellant received a 40-year term of imprisonment, and there's just such a huge disparity with the pretrial offer, which was 10 and then 8.
What did the shooters, I know they were much, much younger, but what did they end up with again?
The shooter, one had a 4-year sentence, and the other had an 8-year sentence.
And we're dealing with a 14-year-old, a 16-year-old, and a 17-year-old.
Correct. So I understand that their youth would indicate some leniency, but appellant at most is the driver. At most, he's the driver.
Well, he could be the mastermind too, but that's another.
Well, I mean, could be, right? That certainly isn't demonstrated in this record.
We'll look at it really.
The other part of the sentence I just would like to stress is.
So were you asking us to run it concurrent? Is that what you're asking?
To reduce, I think the Daskowicz case is one that you, Justice Sentra, and Justice Winslow were on. And I mean, in that case, you have a victim that has to testify in a sexual abuse case. And the court still elected to go from 40 to 15. And here, 40 to the pretrial offer of 10, I think is more commensurate with his actions and congruent to the sentences of the shooters. Unless there are questions, we'll rely on our brief. Thank you.
Thank you.
Good morning, Your Honors. Ken Tyler for the People. Justice Sentra, you stole my thunder for the first 2 points. I agree. The video is obviously what we're relying on. That's really the probative evidence here. As to the conflict, I think it's, if anything, it's 440 territory. There appears to be a potential conflict to me, but I can't say with confidence about the timing whether there's concurrent representation there. I don't think there's really any record support for the idea that a conflict was actually realized because the victim didn't testify at trial.
It just doesn't make any sense, though, to appoint a lawyer who represents the victim. I mean, it's not like Syracuse is a small town. Like, just get another lawyer.
No, I agree with that.
It's just
It doesn't.
perplexing to me that would have even occurred.
Yeah, no, I'm coming in 3 years later and I'm viewing it with the same perplexity as you are. I mean, it seems like it'd be avoidable, and if nothing else, I mean, the potential conflict was brought to the attention of the court by the prosecutor. So we were cognizant of it, trying to cut off any issue there, and then it wasn't taken up again. County court should have taken it up again. I don't disagree with you, but I think it's an off-the-record issue. As to the sentence itself, I recognize the disparity between a pretrial plea offer and the ultimate sentence imposed, but if the only redeeming thing that a defendant can say is, my sentence should be lower on an attempted public execution, is because the prosecutor undervalued or somewhat misvalued their case, I just don't think that serves the interest of justice here. And I know everybody's familiar with the record, but I would just point out, as you recognize, all of his cohorts were significantly younger. I don't have his age in front of me. He's 27 years old. He's equally culpable. He has 4 prior felony convictions. He was on parole at the time he committed this offense, which again, attempted public execution at a busy intersection. Those factors, if the best you can say is, well, the prosecutor undersold it before trial, that doesn't serve the interest of justice. It was a different charge. The plea offer was not to an attempted murder. He was convicted of attempted murder. I'd ask you to consider those factors and ask you to affirm.
Thank you.
Thank you.
People versus Anthony Session.
Morning, Your Honors. May it please the court, Dave Juergens for Mr. Session. Under point 1, we're asking the court to consider dismissing the indictment. There's 3 periods of delay that fortunately Judge Morris dealt with in his decision. People concede 25 days for the first period. Judge Morris ruled favorable to Mr. Session that 79 days was chargeable for the people's first request for a trial adjournment.
So what we're really talking about is the period between, correct me if I'm wrong, May 13th through August 4th of
Yes.
2015?
Yes, and that would be 83 days The trial court divided that into two periods, an initial period of 34 days.
And with respect to that period, the court didn't make a ruling.
Correct. He said it may or may not be chargeable to the people. Instead, he went to the filing.
49 days.
Right, and so we're left with the 49 days, starting with the filing of the attorney grievance.
Right.
And it's our position that it's not supported by the case law that automatically stops the people's 30-30 clock. Their theory appears to be that when the grievance was filed, Mr. Session was effectively without counsel through no fault of the court.
Yeah,
and
but the filing
therefore-
of a grievance doesn't automatically require
And-
the assignment of new counsels.
And that's exactly our argument. It's a discretionary decision. That discretionary decision wasn't made until August 4th. At that point, 30-30 time period had exceeded 181 days, and therefore, it's our argument that Mr. Sessions entitled to dismissal.
So we can make a determination about that 49 days, but I'm concerned that based on our case law, which I recognize is a little different than the First Department's case law, that at least under our case law, we cannot make a decision based on the 34 days because of Concepcion.
Well, if the court rules that way, then at a minimum, we would ask for remittal, and remittal is what we're also.
You can't go back to Judge Morse.
True. Under point 2, we're asking for remittal because the attorney basically took a position adverse to his client by filing what I would characterize as a motion not to dismiss. I've laid out the facts in my brief, and unless there's any questions, I would rest on the papers.
Thank you.
Good morning again, Derek Harnsberger on behalf of the people. May it please the court. And so, Justice Peredato, you are absolutely correct that the court did not issue a decision on the 34 days. It appears that the court, looking at the other circumstances, decided that it was not necessary.
So we may have to send it back to.
It's that if the court is going to hinge on the 34 days, there is no ruling. I cannot say that what the court would or would not have decided on that. Obviously, it is my.
Neither can we.
But with that said, with regards to the 49 days, so this is a particular defendant who utilized and abused the grievance process on 3 different occasions. The record is replete with examples where the defendant was engaging in a course of conduct where he would disagree with his attorney on something, file a grievance, and then complain about the delays associated with the grievance. In this particular case, the 49 days could have been alleviated by the defense attorney accelerating the process, going back to the court and indicating, Your Honor, there's been a grievance filed, I want this issue broached. The problem with endorsing this conduct becomes with a defendant like this, where he waits for a lengthy chargeable period of time. So he sits there and asks for a 4-month adjournment, grieves the attorney halfway through, and then says, Your Honor, I want all 4 months to be chargeable to the people.
Well, the people could have made the same request. The people could have made the same request of the court to inquire, to make a determination as to whether counsel needed to be relieved or not.
If the record supports that the people were aware of that. And that's the inherent issue here, is that there was no indication that the people were aware
Of the grievance having been filed?
of the grievance being filed, because this is a situation between an attorney and a client. The attorney grievance committee would contact the defense attorney. In this case, the commission indicated that they were going to conduct an investigation into the defense attorney, and that's ultimately why the counsel who was a part of this 49-day period was ultimately relieved, because he reported to the court that the allegations in which the defendant filed against him were sufficiently egregious, caused the investigation, and he has to be relieved.
How many, did he file grievances against all these lawyers here?
Correct.
He started with Schiano, then he went with Matt Rich, and
Correct.
then he ended up with James Brown?
Correct. And there was a grievance on all 3. And that's why.
And he had another one.
Correct, and that's why Teo Seguenza was assigned at sentencing to revisit what happened in the 3rd. But the record is crystal clear that he filed a grievance against Schiano originally. He filed the grievance against Matt Rich, that was the 49 days.
And I guess that was based on Matt didn't object to the adjournment.
Unfortunately, the grievance was not made part of the record here, so I can't say exactly what the nature of the grievance was. He did make statements in passing that he disagreed about the way Matt addressed the particulars of looking into adjournments. But what he actually ultimately alleged isn't a part of this record, but we do know that counsel did say, I'm asking the relief because it was serious. So I would just encourage the court that in analyzing that 49 days, to exclude the 49 days to ensure that defendants are not otherwise encouraged to grieve their attorneys and otherwise utilize the attorney grievance process as a sword to evade responsibility under speedy trial.
Thank you.
Thank you.
People versus Richardson. You're solo, Mr. Tyler.
Good morning again. Ken Tyler for the people. I think Mr. Stenough is submitted. Hopefully he's not feeling conflicted on this matter as well. The people will rest on their
Thank you. People versus Alvin King.
May it please the court, Gary Muldoon for Alvin King. In this weapons possession case, the word constructive comes up quite a bit. Constructive possession, joint constructive possession, and also constructive amendment of the indictment. 8 people were arrested that night for possessing 3 weapons, and Mr. King was the only one indicted. The evidence showed that the DNA of 4 people, including Mr. King's, was on the handgun that was found in the ceiling. And his DNA was the most. No one else was indicted for possessing it. He was also arrested that night for shotgun possession, though he wasn't indicted on that. And that's part of the record on appeal on page 5.
Well, with respect to the DNA evidence, would you agree that that's strong evidence that he physically possessed the gun at some point in time? Maybe not on the day alleged in the indictment, but that's evidence that at some point during his lifetime, that gun was in his hand.
No, Your Honor, I do not agree with that.
Your theory is that it might have been transferred from the paper towel or somehow transferred onto the gun?
Yes, Your Honor. As the people's own expert witness testified, there can be secondary transfer, and that can occur through sneezing, through shaking hands, through perhaps from the paper towel, but it was never established how that could have happened, particularly on an evening where there's a half a dozen people or so, 4 people to 8 people.
Well, even if he had at one point, sometime in his life, touched that gun, that doesn't mean that he knew it was up in the ceiling.
That is correct, Your Honor. So the one point that I would make, as both of you adverted to, was that at some point he might have touched it, but not on the date and time alleged in the indictment.
That was the question that Judge Lindley asked. I mean, that it appears to have been that there's evidence that he touched it at one point, but what point that was, whether it was that day, the day before, or a week before, or a month before.
That in and of itself renders the case charge against him to be defective. But the second argument I would make is that there is the possibility, as the expert witness suggested, of secondary transfer.
Let's even take that out of it. Let's,
you don't even
for
need that.
purposes of
Correct.
argument, to say, yeah.
Very good.
He touched it at some point.
Wonderful. Thank you, Your Honor. One of the things that happened in this case was that the prosecution, at the end of all of the case, at the jury conference, requested a charge on joint constructive possession, which requires either that he has dominion control over somebody else who possessed it, and nobody possessed it, or that he had constructive possession of it through his dominion and control over the location. And there were several other people who were located in this card room, and it was not shown that that occurred at all. I submit that there is a variance in the indictment, that there was no showing of constructive possession, joint constructive possession. I would note that When it comes to joint constructive possession, joint with whom? We don't even know the names of the other people who were in that room, other than in that page 5 of the record on appeal, which lists 7 other people who were charged with criminal possession of a weapon. So who was he in joint constructive possession with?
Okay, I think we have that argument.
Okay. The last point, Your Honor, that I would address is the prosecutorial misconduct. And the district attorney said he had nothing to worry about anything else in this case. He did. He was the person, he was one of 8 people actually, who was arrested for criminal possession of a weapon of the shotgun. He has a previous conviction, previous felony conviction of aggravated operation of a motor vehicle. He was charged with criminal possession of a weapon along with 7 other people. They got no bill apparently, but he had good reason to be concerned about that. There was also a misstatement by the prosecutor on summation regarding what the 54 quintillion, I think it was, could have meant, and that she said that it must have meant that he actually touched it. That's not what the expert said. I'll rest on my papers for the rest of the points.
Thank you.
Thank you.
Morning. Please the court. Marty McCarthy for the people. I'll start with the end there, prosecutorial misconduct. 2 of the instances pointed out by counsel were not preserved by objection. With respect to the issue of what the defendant had to worry about, he's referring to the text message that was sent from the defendant's phone. That's a meaning that counsel's ascribing here. Counsel was free to ascribe that meaning to those words at trial level, and so was the prosecutor. That was fair comment on the evidence. The fact that the defendant was charged with that shotgun but not indicted on that shotgun doesn't mean that that's the only thing he was worried about. With respect to the DNA evidence and the prosecutor's comment on the DNA evidence, during his summation, trial counsel, defense counsel stated that there were a number of inferences that can be taken from the DNA evidence, and the prosecutor was simply inviting the jury to take one particular inference, which was he possessed that weapon, given the fact that that weapon wasn't located 100 miles away from him. It was located almost directly underneath him in a room that he was playing cards in.
It was in a drop ceiling.
It was in a drop ceiling,
It wasn't
yes.
underneath him, it was over him.
Correct, it was over him.
It was above him. And in order for that to be reached, didn't the evidence technician, didn't they have to use a ladder to get it?
Correct. I don't know if it was a ladder or a chair, but yes, they
So
needed.
that point, I think, is, there was a ladder. But my understanding of the record is that the ladder was needed. A female officer stood on the poker table, was unable to see. I guess there were tiles missing. She was unable to see into the ceiling. So then somebody got a ladder and to see. But whether you can see, I mean, whether you can reach up and put a gun there is different than whether you can see what's up there, right? And that was my understanding, is that, I mean, the mere fact that somebody couldn't see what's above the drop ceiling doesn't mean that somebody, like this defendant, couldn't have reached up there and put the gun there.
Yes.
Is that
Yes.
your understanding of what the record is?
Yes. And if this was simply his mere presence in the room without the DNA evidence, this would be a different case. This would be a mere presence case.
What do you say?
And there would have been no evidence. I'm sorry, Judge.
What do you say about the argument Mr. Muldoon raised in his brief and this morning that the DNA evidence merely shows that at some point in time he possessed the weapon? The indictment alleges he possessed it on that date in question, at that time in question.
Yeah.
And so the DNA evidence doesn't establish his possession as charged here. It may have occurred on another date, and it's not charged.
Well, the jury's entitled to make reasonable inferences. And here, the reasonable inference was he possessed it on that day because he had physical proximity to it. Even though it was located in the drop ceiling, he had physical proximity to it. So the fact that.
What do you
his-
mean by that? That he had physical proximity? What do you mean by that?
Well, it wasn't like, the people charged the defendant with possessing this weapon that was found a block away, 2 blocks away, and there's no evidence tying him to the area in which the weapon was found, or no other evidence tying him to the area where the weapon's found.
So what evidence did tie him to this area? He didn't own it, he didn't rent it, he was playing poker there.
He was playing poker there. He and a number of other people are playing poker there. And if the DNA evidence itself wasn't on the weapon, I wouldn't be here. This wouldn't be an argument. This would have been dismissed on the grand jury minutes, or would have been dismissed on trial dismissal. But the addition.
That the fact that he physically possessed it, that a reasonable inference can be made from the DNA evidence that he at some point had the gun in his possession. That evidence goes to constructive possession. The fact that he at some point possessed it is relevant to determining whether he constructively possessed it when it was up later, when it was up in the ceiling.
Correct.
Which was in the same room he was in that was accessible to people.
Correct.
Standing on tables and reaching.
Correct.
Is that?
Now, if this had been found in a locked safe, that might be a different story, because a locked safe, he doesn't have the combination to, he can't exercise dominion and control over that area. Anyone could have lifted that drop ceiling tile, anyone could have placed a weapon up there. It's a people's contention that the defendant did those things. But it's the addition of the fact that there's DNA on the gun, which adds the element of possession, and it doesn't just make it just a mere presence case.
I think we understand that.
Okay. Anything else?
Thank you.
Thank you.
Lisa Ann Harmel versus Mercy Hospital Buffalo Orchard.
Good morning. The plaintiff sued Dr. Kaushal, that's my client, the appellant, and many other care providers, alleging malpractice over the course of 3 visits to an emergency room.
Yeah, we know all the facts. If you can get
Okay.
right to your argument.
Dr. Kaushal, in his motion papers, made out a prima facie case of entitlement to summary judgment, and the court agreed. He put in his own affidavit, and he explained what he did, why he came to his conclusion. He called it primary physician, and so on. Plaintiffs, in putting in an affidavit by their expert, Dr. Jubaniuk, first claimed that, well, there's a battle of the experts, so, you can't win. We are not claiming that our expert's better than hers. We're simply claiming that her affidavit is speculative.
Well, Counselor, address for me the proximate cause issue of Dr. Kershal's. How is the allegations conclusory insufficient? Why isn't it?
Well, at the end of her affidavit, the Dr. Jubaniuk says, well, the doctor, my doctor on the 7th, either should have had a surgical consult or an admission. And that's where she ends it. So she doesn't say a surgical, and now you have to remember how highly compromised this woman was with all of her other problems, vascular, heart, kidney, lung, all the surgery she'd had, all the medication she was on. This isn't a general population question. This is this specific woman. So it was incumbent on this expert to say more than just, oh, she should have had a consultation with a surgeon. She doesn't opine whether any surgeon would ever have agreed to operate on this woman, what kind of surgery, what the outcome would be, whether the poor woman herself would say, sure, I'll have another surgery, given her state.
Yeah, but how does your expert address that?
Well, my expert is Dr. Kaushal, the defendant himself.
I understand.
He says nothing. If you look at his affidavit, he says how he treated her and that he came to the reasonable conclusion that she had constipation. The evidence was overwhelming. It was radiological evidence. He treated her and her symptoms of pain came down, and her other abnormal lab results could all be explained by her many other problems. So it was reasonable for him to say she had constipation. Nothing he did was wrong. Nothing he did led to her early demise.
Okay, we'll look at that really carefully. Thank you.
Okay. Then I want to talk about the conclusions that Dr. Jabonic reached. They were entirely conclusory. She has no foundation. One, she says the diagnosis of constipation was highly questionable. She overlooks all of the evidence in the file, the medical record. The woman complained she had constipation. She hadn't had a bowel movement. The x-ray evidence, the pain that was consistent. The follow-up the next day evidence showed diffuse constipation. She ignores all of that. What does she say? The plaintiff's expert? Well, there was an abnormal lab, and constipation wouldn't account for that. Nobody said it did.
Okay, we'll look at that.
All right. And then more importantly, she says she had small bowel obstruction. But if you look at her affidavit carefully, the only time she says that is in the end, paragraph 26 and 27. She says, on every admission, and I only care about the first one, the only time my doctor saw her, everything pointed to small bowel obstruction. It's completely all-encompassing. But if you look back at what she said before, she says one thing about small bowel obstruction. She had a risk factor, and the risk factor was she had had prior surgeries. She recites what the patient had on December 7th. Yeah. But she never says, this is indicative of small bowel. That's indicative of small bowel. This suggests small bowel.
We'll
Never.
look at that very carefully.
Okay, and the x-ray evidence as well doesn't show small bowel obstruction. The expert doesn't rely on the death certificate. She mentions it in passing. The argument in the plaintiff's papers talk about the death certificate, but it doesn't support her. It says her vascular condition finally causes diminished blood supply to her bowel, and that caused it to be necrotic, and she died. Nothing about small bowel obstruction.
Did you say the x-ray or the CT scan did not show a small bowel obstruction?
She had 4 films. On December 7th, my day, she had an x-ray, which the expert doesn't even acknowledge existed, that said nonspecific loop or something, nonspecific. And then the radiologist said, if clinically there's a concern for obstruction, you might want a CT. The x-ray never said, ooh, there's an obstruction. So Dr. Kaushal...
Wasn't there some record that said it was suggestive of a bowel obstruction?
Yes, if I may, that's the very last one.
Okay.
So on December 7th, what my doctor had was that x-ray, so he read it and said, okay, I'll order a CT scan, which he did, which also showed diffuse constipation, no obstruction. The next day was another
That
x-ray.
CT was without contrast, right?
Yes, Your Honor, and if I may, I know this isn't a winning argument most of the time, but this expert was not qualified to talk about, I saw your eyebrow raise. But really, because it's a very low threshold. The expert says, I had a class, I read up on it, I had a little experience with it, fine. You say, go ahead and opine. This expert does nothing. She never said she even ordered, or that she orders CT scans. She doesn't say she has any familiarity with diagnosing small bowel obstruction. She doesn't say in her facility, it's the emergency room doctor who makes that decision. It might be the radiologist who makes that decision, whether it should be with or without. This expert said absolutely nothing about her expertise, her education, her anything.
I think we understand.
Okay. And in addition, the expert's contradictory. She acknowledges that this poor woman has one kidney that's very compromised. Oh, maybe you shouldn't have intravenous, but you could have oral. She doesn't explain how the oral contrast wouldn't compromise her poor kidney again, or the ileostomy, why the oral wouldn't just go out the ileostomy. She needs to explain more before she makes these pronouncements. So that's the CT, no obstruction. The next X-ray, no obstruction. And Your Honor, about the fourth one. The fourth one is a very short time before she dies on her 3rd admission. So my doctor did not have that. It said suggestive of, which is not a diagnosis. Nobody in the hospital on a third admission made any reference to it, made any reference to small bowel. The doctor who signed her death certificate or declared her dead, nothing about small bowel.
Okay, I think we understand that.
And even the expert herself didn't mention it. She, in passing, when she's reciting what happened, she has no foundation for her giant conclusion. If I may say one more thing, because truly, she says, on every admission, everything shows it. This lady's symptoms, her physical exam, her vitals were different on admissions. One time they're high, one time they're low. One time they're slight, one time they're very high. So to say everything, well, which all of them? The high one or the low one?
Okay. Thank you.
Thank you.
Good morning, Your Honors. Ed Markarian for the plaintiff. I'd like to start with a quote from the affidavit of the defendant himself, and this is regarding the x-ray on the day he saw the patient. The radiologist reported a clinical concern for obstruction and suggested a CT scan may be useful for further evaluation. So the x-ray on the day that the defendant saw the plaintiff, the defendant himself is stating in his affidavit, he knows that's showing a concern for obstruction. He orders a CT scan without contrast. That's in violation of the standard of care. You have to have either a test that's going to help you, or you need to admit the patient for observation and treatment. That's what the standard of care required. I disagree that the plaintiff's expert was conclusory in any way. This is a quote from the plaintiff's expert. At every visit, the history of physical symptoms, physical examination, available labs, x-rays, and vital signs all point to a small bowel obstruction that progressed to bowel ischemia, bowel death, and then sepsis with metabolic acidosis that caused the terminal event of a cardiac arrest. If the bowel obstruction had been diagnosed, she more likely than not would have survived her small bowel obstruction. It is my opinion with reasonable medical certainty that the defendant deviated from the applicable standards of care in failing to properly and timely diagnose and treat Mrs. Harmel's small bowel obstruction.
Okay, you don't have to read the whole thing.
I know.
We
I just want to
obviously have read it.
emphasize that it's very thorough, and that it's not just that these were indicators of constipation. These were indicators of something much more serious. She had no history of constipation. She was taking medicines that would cause diarrhea, not constipation. Elevated blood pressure is not a sign of constipation. Racing heartbeat is not a sign of constipation. Labs showing infection are a sign of a serious abdominal problem, not constipation. The plaintiff's expert goes through all of that. And we have the x-ray. The x-ray is saying there's a concern for a bowel obstruction, so you have to order the right test. He didn't order the right test. And then I think it's important to look at the defendant's affidavit. I personally view the defendant's affidavit as an admission. He says, I was concerned about small bowel obstruction, but I thought constipation was more likely. But when you've got that on your plate as a doctor, the standard of care requires that you rule out the life-threatening condition. He never says in his affidavit that he ruled out the life-threatening condition. He just went with a hopeful wish that it was constipation. He also medicated the patient with opioids, which masked her symptoms. He never ruled out the life-threatening condition.
I understand that.
So we submit, Your Honors, that the record is very strong, that at a minimum, there's a question of fact whether the defendant was liable, and we ask that the court affirm.
Thank you. Julio Luciano versus State of New York.
Thank you, Your Honors. Counsel Siddhartha Rao for Appellant Dr. Julia Lucinio. May it please the Court. This appeal concerns a decision and order of the Court of Claims that...
We know exactly what it's
Okay.
about. We're going to
Very
get right to the argument.
Okay. I'd like to take the argument in two parts, if it's fine with the Court. There was the denial of the or the granting of the motion to dismiss and the denial of the leave to amend. And I would like to start with the grant of the motion to dismiss.
So let's get right to the grounds for that. The claimant's contract was never approved by the state comptroller as required by the state finance law. How do we get around that? That was the basis for the grant of the motion to dismiss. And how is that not, why was that not proper?
That's correct, Your Honor, as to the basis for the grant. Claimant respectfully submits that the approval was not required, the comptroller approval was not required under the state finance law. And I have 4 arguments to present to the court.
You seem to argue that if somehow another falls under the preview of the civil service law, Article 14.
That's correct, Your Honor. That
And how does that occur?
Well, the state finance law specifically exempts any agreement or contract negotiated pursuant to Article 14 of the civil service law. And we've argued.
This was not a negotiated contract, though. Your client was hired to be the dean of the medical school. I mean, this was not a contract that was negotiated with a union.
That's correct, Your Honor. It was a negotiated contract, however. Our client did engage in months of negotiation.
Your client did, but this was not a union negotiated contract. Isn't that what is required to fall within the exception?
Respectfully, we disagree. We think the exception covers all contracts or agreements under the Taylor law.
What authority do you have for that?
So the Taylor law defines an agreement as a publicly bargained agreement, but the exemption in the state finance law covers contracts or agreements. And so we'd start with the language. In terms of case authority, the only case that is considered the application of comptroller approval to a management confidential employee is Wright versus Cayenne, and that case held that management confidential employees are subject to the exemption because their contracts arise under the civil service law.
I did read that case, which the state seems to ignore. And I'm surprised to see that it does say what you say it says, and then it was affirmed by the Second Circuit. But the way I read the case, it was a secretary in Wright who worked for the president of the university, SUNY. And she made over whatever threshold it was lower than.
Yes.
And the court said the controller, it wasn't subject to controller, that there had to be no, it didn't fall within the state finance law there. But the way I understood that case is there was no contract there. She just got hired administratively. They said, "Do you want a job?" She took the job. She worked for the president. So there was no actual written contract.
Well, I would actually disagree with that. Footnote 2 of the opinion recites the entirety of the offer letter, which was given to Plaintiff Wright. And I believe paragraph 2 of that offer letter identifies Wright as a managerial confidential employee. So in actually every respect, that case is on point with Dr. Licinio's case. He also was appointed pursuant to letter. He was also identified as a managerial confidential employee. And I would point out from a perspective of statutory construction, the term managerial confidential only really arises from the Taylor law. The Taylor law is yes, we concede it's a public bargaining statute, but ultimately it was amended to classify certain civil servants as managerial or confidential based on whether they are policymakers or advised policymakers. So in the Wright case, for example, the plaintiff was advising the president, who was a policymaker and therefore was classified as managerial confidential.
So you say that the agreements here, the letter offers, were identical in nature in Wright and in our case at hand?
Yes.
It wasn't a formal contract where people, both sides sign it like you would see in a typical employment contract situation. It was similar in nature.
It was very similar in nature. It was an
to what
employment
we
letter.
have.
The differences are not relevant, but I would cite them, which is that Wright was in the, I believe, the exempt civil service class, so that is exempt from competitive examination, whereas Dr. Licinio would be the unclassified civil service class. But those distinctions don't bear on the issue here, which is, do they have enforceable contractual rights or enforceable contracts?
Did you cite Wright to Judge Fitzpatrick below?
We did.
And she didn't mention it in her decision?
She did not mention it in the decision.
And the state ignores it?
The state ignores it. Well, again, I don't want to step too far. The state attempts to distinguish Wright in a footnote. In our view, the state, in their opposition brief on appeal, in our view, that footnote completely misses the point of the Wright case, and the distinction is not.
You must have missed that footnote.
Okay.
Okay. So from an authority perspective, we have the case of Wright versus Kyan. From a statutory language perspective, we
Yeah,
have.
we'll look at all that.
Okay, we have agreement or contract. There's also a policy argument which we made here, which is, in the record at page 422, we have annexed the Government Office of Employee Relations Manual for Management Confidential Employees, which clearly states that most management confidential employees are on salary scales and are paid through legislative enactments and budgets. The lower court ruling taken on its face essentially says, if you are a management confidential employee, you have no enforceable employment rights unless you can show comptroller approval. That's unworkable in practice. We have over 10,000 management confidential employees statewide. The majority of them do not have individualized contracts. And while they're not in specific negotiating units, as their counterparts in the union are, they are in units that are paid roughly similarly to their union counterparts. So the opinion below would work a policy nightmare where essentially 10,000 management confidential employees are being
We'll
told.
look at that policy.
Okay.
What about your motion for the leave to amend?
Right, so on the leave to amend, first of all, the standard is that it's liberally granted, and we respectfully submit the court applied an overly searching review of the pleading and denying the leave to amend. As a procedural point, the prior counsel brought this as a leave as opposed to amending as a right because the amendment would have included fraud claims. And for intentional torts, there's a 90-day notice requirement under the Court of Claims Act. And because they were out of time on the 90-day notice, assuming accrual as of the date of the contract breach, in an overabundance of caution, I believe counsel made a motion for leave to amend rather than to amend as a right. It still was within 40 days of a responsive pleading. So I just want to point out that procedural issue. On the substance, look, we have in the affidavits and the pleading extensive references to the months of interviews that Dr. Licinio conducted with the state university, the fact that in reliance on those interviews and the repeated promises made to him that these contracts would comport with state law, he relocated his entire family from Australia, which is not an insignificant fact, to come here, and he declined alternative job opportunities, such as at the University of Arizona. So taking that all into consideration, our amended claims really arise out of those collateral promises. And we respectfully submit that the decision misconstrues the effect of the, I'll start with the implied contract. So the decision distinguishes between an implied in law contract, implied in fact contract, finding that what we have alleged at best is an implied in fact contract and would still be subject to comptroller approval. Respectfully, we would submit that comptroller approval is conditioned on a threshold monetary value of $50,000. Some of the case law we've cited, it says that when a contract doesn't have a cognizable value at the time of its making, it's not subject to comptroller approval. Here, the implied contract would be the several promises made by SUNY officials, including the president and several administrators.
So you can kind of circumvent, assuming that the state finance law applies, you can circumvent that by relying on implied contract?
Well, I understand the question, and I would distinguish this case from other cases that say that one cannot circumvent in the following way. This contract really was drafted to look like a civil service contract, and what those cases say is ignorance of the law is no defense, and one is charged with knowing that comptroller approval is required. The claims here, particularly the fraud claims, really get to the idea that the state, if in fact there was some approval requirement, they concealed it in the drafting of the contract, that Dr. Licinio's counsel, even exercising the most due diligence, would have come across the Wright versus Kyan case, would have known that management confidential contracts aren't subject to comptroller approval, and that all of the reassurances of the state would have bolstered that impression that in fact approvals were granted. The contract not only references and recites the management confidential language several times, but specifically identifies policies that govern that contract and does not and completely omits any references to state finance law. So the argument is really of a twofold nature. One is that there was certainly an implied agreement to obtain approvals, but in terms of the fraud and the fraudulent concealment, the argument goes further, which is to say the state actively concealed, essentially on purpose, any comptroller requirement to such a
Well,
degree
that would
that.
be actively, it would be on purpose.
And you
but-
say that because you say there should have been some sort of clause in the contract that's saying that this is subject to the state finance law?
Well, that it would not be a civil service appointment under, despite all the language suggesting that it is a civil service appointment, that it is
That it isn't, so, okay.
a management confidential appointment that is specifically defined in Article 14, that somehow that's not really the case here. That
Okay,
that
I
would
think
be.
we have that argument, and you should wind up.
Okay. If there's no further questions, we rest on the papers.
Thank you.
Thank you.
May it please the court, Frederick Brody for the state. The judgment should be affirmed. Licinio's claims are barred by state finance law 112(2)A. The Taylor law exception does not apply here. State finance law 112(4) exempts any agreement or contract negotiated pursuant to the Taylor law. And the key words are negotiated pursuant to. Pursuant
And again,
to.
there's no, this is not a union negotiated contract, correct?
Right, and the Taylor law authorizes negotiations with unions. It doesn't authorize negotiations with management confidential employees. Those are part of the state.
Could you distinguish the Wright case? Counsel says you failed to distinguish it, and he says it's right on point.
Yeah, thank you, Your Honor. I did address the Wright case. It's on footnote 5 of pages 12 to 13.
You don't seem to distinguish it, though.
I did distinguish it. Wright doesn't apply because look at the holding of the case. Forget the dicta, which are a federal trial court. Look at the holding of the case. It says the thing agreed upon, which was due process protections prior to dismissal, a for-cause requirement, a notice requirement. That thing was, quote, not susceptible to valuation, close quote. Therefore, the contract alleged was not subject to 112 because each of the prongs of 112 requires there's a $10,000 valuation for non-monetary and there's a $50,000 threshold for monetary. And he said, well, we can't value these due process protections. Therefore, it doesn't apply. That was the holding.
There was dicta from the federal district judge, McAvoy, who said very clearly this contract is not subject to approval by the controller. There was that dicta. You describe it as dicta probably correctly, but you acknowledge that the judge was of that view, that the state finance law didn't apply to that contract.
No, I think what I just said, that it wasn't monetarily valuable, could not be monetarily valued, that was the holding. That wasn't dicta. Everything else.
I know. Okay.
Yeah.
He has dicta that he says support his position.
Okay.
Right. So you're saying we shouldn't follow dicta. But the point is the judge was of the view that's consistent with his position.
A federal trial judge may have held that view, but I'm looking at the holding of the case. Holding of the case says state finance law 112 doesn't even apply because you can't value it.
Right. We don't have to follow dicta from the federal district. But he also says, and I'm curious as to your response, he says, in the last 18 years, for which public records are available, SUNY has not submitted a single dean or administrator contract to the controller for its approval, for his approval, including the replacement of the dean of medicine for his client. Is that accurate?
Well, as far as I know, it's accurate. I haven't looked at the many letters that were,
So
whether
then
they were or
SUNY
not submitted.
is wholesale ignoring the state finance law.
Well, let me.
When they hire all these deans, they just ignore the law and don't submit a single one of them for the last 18 years to the controller.
Well, let me give you an explanation on that and push back just a little bit. SUNY didn't send its offer letters to the controller because it didn't regard offer letters as contracts. A plain vanilla offer letter generally says, we invite you, the applicant, to come work for the state as a management confidential employee. Your employment is at the pleasure of the appointing authority. The salaries, benefits, and terms of your employment are all set by statute and by regulation. So your average management confidential employee, it's not a contract because it's at the pleasure of the appointing authority.
This was a contract, though, here?
This was a contract, I think,
Why?
because
Why is it different than
when you add bells and whistles to your typical plain vanilla offer letter, at some point, you cross a line and it becomes a contract. And that may be, well, what happened here? I mean, you've got $585,000 salary, which is sort of off the charts. You've got all sorts of terms that the comptroller might well have
So
questioned.
At some point, an agreement becomes a contract, that's subject to approval by the comptroller.
That's right.
You have terms and conditions, regular agreements you don't have to submit.
Well, an offer
But
letter.
if you add bells and whistles, then it becomes a contract, and then it's subject to approval. That's
right,
what you're
that's right. So, you know, the claimant is trying to enforce this as a contract. So if the court concludes that it's a contract, and if the
Then it
court...
would have to go through the approval.
Right. The court
Okay, I
says,
think we
Suni,
have-
you're wrong.
I think
Now,
we
if
have-
it's not a contract, of course, it's not enforceable because you serve at the pleasure of the appointing authority.
No, it was a clear breach here of the contract. You would have conceded that point? Clear breach of that they didn't give him the 8 months notice, they just fired him right away?
They didn't give him 8 months.
So it's a clear breach, but you're saying it doesn't matter because the contract can't be enforced because it wasn't approved?
That's right. You get, you know, some unfortunate circumstances in these 112 cases, but as the Court of Appeals explained in Parsa, the burden is placed on people who contract with the state to make sure they know about 112. The burden's not placed on the people, the taxpayers, the people who are protected by
Do you
112.
want to address the leave to amend?
Sure. All of the theories on the proposed amended claim are attempts to circumvent Section 112. But Section 112 can't be circumvented. That's the case law we cite in our brief. The implied contract claim is barred because an implied contract is still a contract. Implied contracts fall within Section 112(2)(a), as the Court of Appeals held in Parsa. And Dr. Licinio cannot circumvent Section 112 by alleging an implied contract to obtain the controller's approval. That would undermine the controller's independence by allowing a SUNY employee to bind the controller to approve the contract or else subject the state to damages. And there's no contract implied in law either. The Court of Appeals has made clear, again in Parsa, that a court's equitable powers don't override a statute. And here you have a statute, Section 112, that says, for the protection of the public fisc, every contract over
Has to be
$50,000.
approved. Okay, we understand that.
Right. As far as the implied duty of good faith, which is the second theory, duty of good faith, again, it's an implied duty in every contract. If the contract isn't enforceable, the implied duties aren't enforceable.
Anything further?
The last thing I'll address is the fraud claim, Your Honor. The supposed concealment of Section 112 can't be the subject of a fraud claim because there's no justifiable reliance. In Parsa, again, people who contract with the state are charged with knowledge of the governing statutes, including 112. Because Licinio was deemed to know about 112, he can't have been defrauded. And also a fraud claim, again, it would improperly circumvent Section 112. It would make the state liable on an unapproved contract based on things a state officer said or failed to say. Now we know, and there's lots of cases on this, that state officers can't waive 112. If you can't waive 112, then you can't get around 112 through false statements either. Whatever the state officers say doesn't matter. In the end, people who contract with the state for over $50,000, and you have that here, you don't have that number in those offer letters, the thousands of other offer letters. People who contract with the state are responsible for knowing the law.
Thank you. Tammy Spencer versus Adnan Siddiqui? Siddiqui. What do you say?
Siddiqui.
Siddiqui. I don't know.
Thank you. It is Siddiqui, Your Honor. Good morning. May it please the court. My name is Lawler Quinlan, and I represent Dr. Siddiqui. And the device at issue in this case is a miraculous device that is used by neurosurgeons across the country to prevent strokes and to save lives. It had been used by Dr. Siddiqui every time it worked, 100% of the time that he had used it leading up to this incident. On this day, the device...
And the first one actually worked on this particular...
Exactly,
This
Justice
is the
Paradal.
second one that failed to open.
It's the second one. It was a device malfunction. And the plaintiffs are saying that this should be the fault of Dr. Siddiqui for essentially two reasons, neither of which should be permitted as a matter of law. The first is the criticism that there was a lack of informed consent based on Dr. Siddiqui's failure to inform the patient that this particular device, although it was approved by the FDA, was not approved for certain types of aneurysms.
Off-label, is that what you're talking about?
Off-label use. And Your Honors have got to be familiar with that, I'm sure, from all kinds of other cases of medicines. Off-label use is done more often than not in medication.
Right, which is, it seems to be an odd term to use, because when you hear off-label, you're assuming that it's not proper. But when you look into it, it's authorized, it's accepted medical procedure to use off-label uses, and so it's just an odd terminology that sounds worse than it really is. Is that?
Your Honor, that's exactly the case.
It's not contraindicated, I guess.
What's that?
It's not contraindicated.
It's not contraindicated. In other words, something that's not been approved is not necessarily disapproved.
Right,
or
that's
unfavored.
exactly what we're all saying. so.
Okay, all right. And I guess, and a lot of times, Justice Smith, when I come up here, I wish I were more articulate than I am. But I know articulate, I know learned when I see it. And when you look at the opinions of the unanimous Supreme Court of the Supreme Court of Pennsylvania, the nearly unanimous with a two-word dissent, highest court, the Court of Appeals of the state of Maryland, you look at the intermediate appellate courts of 3 other states, this isn't like there's a split in the circuits or a division of the states. This is a landslide of legal opinion on one side and nothing on the other, except for some trial court cases, including the Retquick case that we drew to your attention because it's wrongly decided, in my opinion. And the plaintiff submitted nothing, no other cases, no other state, no other... also the federal court, if you look at the Supreme Court from Pennsylvania, they cite the bone screw litigation cases in federal court. The courts that look into this, analyze it, are essentially unanimous that a doctor should not have the duty to inform someone about the FDA status because it's not relevant to the risks at issue in the case. And I really would urge it respectfully this court to write on this because we have the New York County case suggesting that that's not the case, and because we have Justice Marshall's decision now, and because in New York, of all states, if you look at the Maryland case, for example, the Shannon v. Fusco, in that case, the common law of informed consent requires physicians to disclose risks, benefits, and, quote, other pertinent information regarding treatment or procedure. And even where that's the law, Maryland said you don't have to inform about FDA. In New York State, Public Health Law 2801, which this court in Abram, 1989, said that statute was enacted to limit the doctrine of informed consent as it had developed in the case law. In other words, it's to cabin the discretion of courts like Retqua and others who are creating this new law on informed consent. I urge the court to write on this because all the other appellate courts that have looked at it have come out and said that you cannot put that evidence in front of a jury on an informed consent claim. So they're wrong there. The second point, Your Honor, is on the negligence. And that's where we get to the history of Dr. Siddiqui's use of this. In their brief, I mean, they put in their opposition brief, they have all this stuff from the bills of particulars and the attorney affirmation, and I kept looking, what does your expert say? Does your expert support any of this? And it comes down, there's one time in their whole brief, footnote on page 33, where they cite what the guy's opinion is. He says, he's got 2 alleged distinct departures. One is the FDA thing we just talked about. The other, he says, begins with Dr. Siddiqui's admission that there was a foreseeable risk that the pipeline PED would probably be misdeployed, as that had been Dr. Siddiqui's individual experience. He is not basing his opinion that this thing is not a good device on his own experience. For all I know, reading his affidavit, he's never used one. He's not basing his opinion on the scholarly literature, on the medical opinions, on what published opinions about what the state of the art is. He's basing his opinion on a misreading of Dr. Siddiqui's testimony. He quotes that thing where Dr. Siddiqui says on page 634 of the record that he had some issues with the device. The plaintiff's attorney followed up on that, and Dr. Siddiqui said, "You're misinterpreting what I said. Let me clarify for you." And on page 637, 638, 639, 640 of the record, he clarifies it. He says, listen, so by mess up frequently during deployment of the original classic pipeline device, it almost invariably resulted in some maneuvers that you need to undertake to get the device to open reliably.
You don't have to read the whole thing.
Okay, but Your Honor, the point is, it had never screwed up. It had never, yes, it had some trouble. You have to be a skilled physician like Dr. Siddiqui or Dr. Levy to use it. But this device was so helpful, so important, so good to the doctors in this country that Dr. Levy in his deposition described it as a gift from God. It was a great device. And Dr. Siddiqui in his hands, yeah, he had trouble getting it open sometimes, but it always opened. It always worked. This is the first time it ever happened. So for the doctor, the plaintiff's expert.
So there was, I'm still focusing a little bit on the informed consent cause of act or claim. I know you say that your client's history was a good one with this device. It had never malfunctioned, it had always opened, but he was familiar, I assume, with instances of other physicians, and he was with the literature or information in which it did not open. He was familiar that could happen.
Of course.
Do you think he had an obligation to, on the informed consent, to tell the plaintiff that?
Yeah, just so it's clear, no doctor has to give the complication rates of other doctors or even his own complication rate. And I know you're not suggesting that, Justice Breyer,
No.
but he did disclose to her in his informed consent very thoroughly.
That there was a risk it might not open.
Yeah, and there's a risk that and she knows this. This is about the 13th time I think that someone's been in her brain.
Right.
She knows that you're putting instruments, catheters, vessels, pipeline, coils inside the vasculature of your brain. Okay, anytime you do that, there's a risk of stroke and that you might die. I asked her those questions at her deposition. She was very familiar with that risk. So she knows that sometimes a device might cause you to have a stroke or die. It's awful, it's catastrophic, it's a horrible outcome here, but it's not Dr. Siddiqui's fault. It's a device that didn't work, and to put that on him when their own expert says that when he went in there, he did everything right, the surgical technique, no criticism. He just says, well, you should have told her that you had all these problems with it in the past. You should have told her that the FDA doesn't. I'm sorry.
I don't have the brief in front of me, but isn't one of their claims that there are two possible devices that could be used for this? The one that was used and another one that has, it's a little different in how it works, and that her new doctor says that your client should have used the other device, or at the very least informed her of the options.
Yes, so
Isn't that part of the informed consent?
it is part of the informed consent, and that's exactly what he went over with her, and it's in the record, Your Honor. The other device I think you're thinking of is coiling, which she's very familiar with. She has bilateral coiling and the medial cerebral artery on both sides of her brain. Dr. Siddiqui went over that. Like, listen, we can do coiling. We now, as of the past couple of years, have this new technique, this pipeline, which I think is safer. By the way, it is safer. It's way safer than trying to coil in such a small aneurysm. And so he did discuss the other alternatives. That is an alternative treatment. And that is what public health law 2803 says you have to discuss. Alternatives, risks and benefits, and he did those. He did the risks, benefits, and reasonable alternatives. All three of those were discussed, including coiling, which is the other device. So
I think we have that.
Okay.
Anything further?
No, that's all I have. Thank you very much for your time. Appreciate it.
Deborah Little versus Steelcase Inc.
Honors, Philip Rimler on behalf of the plaintiff, Deborah Little. Your Honor, this is a case that really gets mired up in a couple of things, principally COVID-related issues and the pandemic and its impact on operations of our office and, in fact, also operations of the respondent in this case. There was an order that Judge Montour had signed stating that...
Let me ask you something, Counsel,
Yeah.
maybe to get to the heart of it.
Sure.
We're familiar with the order. Is it your position that the executive order told it, and as a result of that, that's why you didn't have to comply?
Well, Your Honor, we did comply, but it's our position that the executive order, as well as Judge Mark's administrative order, told the compliance with this particular order. It was not a self-executing order because...
But those are two separate issues.
They are.
Whether you complied is a separate issue. We may find you didn't comply, but it doesn't really matter if you did or didn't comply if it falls within the tolling period.
And that's our position, Your Honor, that this was told, okay? We made an effort to comply, and then when that...
Right, but that's your whole argument.
That's our entire argument. But then we did then subsequently comply in June, in July, on July 2nd, while the toll was still, all of it was still in effect.
But even if you hadn't, your argument is it was told.
It was
Right, but
correct.
Could you specify, there's two orders here, one's from Marks and one's from the governor, it sounds
That's
like.
correct.
The order that you're saying told your discovery obligations, your clients, was AO 71-20,
That's correct.
and that was issued March 19th.
That's correct.
2020. There's another order, executive order 202.8, that was issued the next day, March 20th, 2020.
Correct.
Am I right on all that?
That's correct.
So you're relying on the 7120.
We're relying actually on both, okay? We're relying on both with
Because one
respect.
of them requires that the excuse be COVID-related.
That's correct.
And they say you have no COVID-related excuse, that it was an office error, administrative problem, so that's why you lose under the tolling, because under one of the orders, it has to be COVID-related, and that's the one that specifically addresses discovery.
That's correct.
There's another one that doesn't say anything about discovery, it's more statute of limitations, that has no COVID-related excuse, and that one doesn't seem to fit here. The one that seems to fit here is the discovery one, but then you gotta have a COVID excuse that you lack.
Well, I don't think, Your Honor, that Executive Order 202.8 is just limited to the statute of limitations in the way that we read it.
It's vague on that, but why would they have an order the day before that specifically
Right.
says, addresses discovery?
Correct.
And then the next day issue another one if it applies to discovery, well, they've already dealt with it.
Well, I don't know what the thinking was at all, because one was issued March 19th, effective, I believe, the 20th, and then the governor's order was more broad and went into effect on 202.8. But clearly, we come under and we've argued in our brief and below, that we clearly come under the provisions of Chief Judge Mark's administrative order.
So then what's your COVID-related excuse?
The COVID-related excuse is, Your Honor, that these items, exactly what's set out in our brief. The Judge Montour had ordered that we submit 40 whatever authorizations, or a number of authorizations. I authorized those to be sent. They were supposed to be unrestricted, and they were not. They were sent out on March 6th. Nothing was emailed or anything. Everything was sent by mail in this particular case. It was not, our office was then closed before the effective date of this order, which would have expired on, I believe, April 10th, 2020. It was my intention that we send out the medical exchange March 6th so that we not have any problems. Quite frankly, that we not be here, okay?
Right. Well,
So anyway, then, I got back to the office, I'm sorry. Judge.
And you laid this out in your brief, but if we were to disagree with you that you had a COVID-related, that the discovery lapse was a result, if we conclude it was not a result of COVID-related excuse, then your focus shifts to Executive Order 202.8. which doesn't explicitly mention anything about discovery, but you say is broad enough to encompass it. Are there any cases that you're aware that say 202.8 covers discovery
No,
lapses?
Your Honor, I'm not. But I think we really have two issues here. We have discovery issue, and then we have the tolling order and the issues concerning the pandemic. And when I got into the office and discovered that that there was an issue, because this was not emailed, it was mailed, discovered there was an issue, we reissued the discovery. And what was pointed out while we were preparing it was that many of the doctors and many of the physicians had either merged or were no longer in business. For example, Dr. Gossi's office was no longer open.
But what does that have to do with COVID-related?
Well, what has to do with COVID-related is, Your Honor, it goes to our compliance to send out, when we discovered that the confusion had resulted in the March 6th medical exchange, we corrected it by sending out additional authorizations in compliance with Judge Montour's order, which, in our understanding of the law, had been told by Judge Marks's administrative order. We then sent those out. The very fact that we didn't send an authorization for a particular physician at the office where our client treated was because those records didn't exist at that office. And we were trying to forestall in a situation where we send out an authorization and then the respondent in the case writes back and goes, well, you sent me an author for an office that doesn't exist. And
I think we have that.
And then with respect to the issue of, so I think in that case there's compliance. I'm not sure what the defense has done with our authorizations over the years. We sent a completely unrestricted authorization for Doctors Fort and also the Diabetes Endocrinology Center in 2018. Completely unrestricted. They never used that authorization. I don't know what they've done over the years. We've sent other authorizations out, completely unrestricted. But just to make my final point on that, the defense made their motion for summary judgment after they had received our medical exchange. I don't know what the COVID-related issues were in their office. We mailed them on July 2nd. For some reason, it took from July 2nd to July 27th to get to New York. They then made their motion on August 6th, claiming in their motion, and they still claim on appeal that we never complied with the judge's order.
We'll look at all that. Thank you.
Okay, all right. Thank you, Your Honor.
Good morning. I'm Tara Fabiano for Steelcase. What this really comes down to is whether it was within the lower court's broad discretion to grant the motion based upon discovery. I listened to the questions during the appellant's argument, and I just wanted to address a couple things. The first is that the administrative order, Judge Marks's order, does require health-related, COVID-related reasons for not compliance, for not complying, and those have never been stated. It's always been law office failure. It's law office failure on this appeal. That's what's talked about here. There's nothing in the record whatsoever to show that there actually was a COVID-related issue. And I think that's highlighted by the fact that the plaintiff's office had the ability to sign authorizations. They just were non-compliant authorizations with the order that had been issued.
Well, if 202.8 applies, they don't need a COVID-related excuse.
And, Your Honor, there is nothing that indicates that 202.8, that's the executive order, applies to discovery. It's never been applied that way. There is no case law that supports that.
But there certainly is no restriction against it either.
There's nothing to say one way or the other, and in this case, the defendant's Steele case, we went to the court and asked for permission to make this motion. It's not as if we just filed and said, you know, we would like you to dismiss the case because there's been COVID-related issues and your case should be dismissed. No, we went to the court, we got permission, there was a conference, the court advised that the defendant could make that motion. So the court, again, has the right to control its own docket within its broad discretion, and it did so here.
And it wouldn't make sense for the governor to issue an order, 202.8 on March 20th, that dealt with discovery, without mentioning discovery. when the day before, the very day before, there's an order issued by Judge Marks, 70-70/20, that specifically references discovery, but says you have to have a COVID-related excuse. It would be, that wouldn't seem to make any sense. We already have a rule on discovery.
Correct.
The next rule seemed to apply to statute of limitations.
Statute of limitations, that's correct. Because at that time, all of us who were litigating at the time, it was virtually impossible to be filing within statute of limitations. Nobody really knew even at that time what to do. So that made sense. It made perfect sense. So they were two distinct issues, and neither one of them excused the plaintiff in this situation. If there's any other questions, I'll be happy to answer them. Otherwise, we'll rely on our brief.
Thank you very much.
Thank you.
Titus Howell versus Timothy Wallace.
Morning, Your Honors. May it please the Court, Timothy Bellavia for the plaintiff, the appellant. This is a motion or an appeal of the judge's decision denying plaintiff's motion on the issue of serious injury pursuant to significant limitation of use and permanent consequential limitation. Your Honor, we think we've established a prima facie case. The injury is a disc herniation as well as a radiculopathy. We have objective evidence that supports the plaintiff's treating surgeon. That includes.
Did your doctor provide quantified restrictions of motion?
No, he did qualitative. And Your Honor, one thing on that issue is the defense medical examiner actually did provide quantitative analysis. He did a range of motion exam and determined that the plaintiff, the appellant, did suffer from significant limitations in his range of motion.
Actually, he said limited range of motion. I don't, in his IME, I don't see that he said there was significant
the case law,
range of motion, but his language is that there was limited range of motion secondary. I don't disagree that, that he made a finding, but there's a big difference between saying limited and significant, right?
You're correct, and what's interesting is when a doctor's writing a report, he kind of doesn't know what does the court consider, what does New York state law consider significant. And in this case, his findings with respect to limitation of range of motion in the lumbar spine when compared to normal, what he did, he said basically.
You mean who, the IME doctor or your doctor?
The IME doctor. Based on his measurements, it meets the New York state definition of significant limitation in range of motion for purposes of the serious injury threshold because it exceeds or well exceeds 20%. So the defense medical examiner.
So the question I have though is whether we can make that determination as a matter of law, because that's what you are seeking. You're seeking a finding of serious injury under significant limitation and permanent consequential as a matter of law. We've got case after case, many of which you cite, in which we deny a defendant's motion for summary judgment, finding that the plaintiff has raised a question of fact with this type of proof. But I couldn't find one case in which we have granted summary judgment to a plaintiff on this level of proof.
One thing that's common about all those decisions, Your Honor, with regard to the defendants that you mentioned is the court concluded that the reason the defendant's medical expert's opinion wasn't sufficient is because it's conclusory. And whether you're rebutting a prima facie case or you're trying to establish a prima facie case, if it's conclusory, my argument is the plaintiff established a prima facie case, and this is all the defendants offer, and their offer contains a conclusory opinion by a defense medical examiner as to whether or not the plaintiff's injury is related to pre-existing degenerative changes or is related to a new injury from the accident. If it's conclusory, it's insufficient to rebut the plaintiff's prima facie case. Here the defense IME doctor says a couple of things. He says, one, there's no pre-existing.
Well, I guess I'm more concerned about whether you met your burden in the first instance, because you need to establish serious injury as a matter of law in the first instance. And so you have to, we're all familiar with the law. Significant means more than minor. Consequential is, the bar is pretty high. And so that's why I asked you about the quantitative. You say that your doctor found qualitative restrictions, and I believe, your doctor essentially said that your client was limited you can't lift over 20 pounds, it's that paragraph,
And-
paragraph
yes, and then-
10 of that affidavit.
Correct, Your Honor. Those are the qualitative limitations. So the opinion's based on objective medical evidence, it's based on physical exam, it's based on a history of no prior complaints of back pain, and then the qualitative.
But I'm concerned that I'm concerned that it doesn't really make any sort of meaningful comparison so that we can distinguish the limitations. So we can make a determination as to whether those limitations really meet the significant or consequential bar. You know, whether the limitations are minor, moderate, or serious as a matter of law.
I think
That's really where I'm focused.
Yeah, I think based on Torrey and based on the progeny that followed Torrey, which was the first case the Court of Appeals says, look, it doesn't have to be quantitative. You don't have to measure.
No, I don't disagree.
But on the qualitative side in Torrey as well, that I think it was Dr. Cambereri was the doctor in that case on the plaintiff's end or the appellant's end. And basically what he was talking about is inability to do household chores, inability to shovel, inability to do certain day-to-day activities, laundry, cleaning, those kind of things. And in this case, we've established, and there's no evidence at all, or no even allegation that the plaintiff had any pre-existing complaints with regard to his low back pain. So here's somebody who's...
But that begs the question. It doesn't mean that, and I recognize we're of course very familiar with Torrey.
Right.
We've seen we've seen
Yeah.
cases involving Torrey issues millions of times. But even in Torrey was a question of fact case. That's where I'm struggling. Do we have a question of fact, or have you shown enough to establish serious injury as a matter of law? I just have never seen a case on these facts that we've decided serious injury as a matter of law.
I think the focus, and you directed it that way, is do we establish a prima facie case?
Right.
And I think qualitatively we do, because if you're going to require an affirmation or
I
affidavit...
think you established a prima facie case. That's not what you're asking us to decide.
Right.
You're asking us to decide this as a matter of law.
Right. Just from the standpoint of establishing a prima facie case on summary judgment, my feeling is once we establish that prima facie case, it's up to the defendant then to come forth with evidence to rebut it.
Right, I misspoke, right.
And that's
Right.
where I'm looking. I'm looking at the defendant's medical expert's report. And the expert report is interesting because it says he has no prior complaints of low back pain. The expert confirms that. The expert goes on to say he has limitations in range of motion, which as measured by the defense expert, this court in New York State law says is significant. And the expert goes on to say one other important thing. His back condition, his lumbar spine has left him with a disability. Those are all significant issues. What's interesting and what's artistic about what the defense medical examiner wrote, and I want the court to pay special attention to this, is he said the appellant didn't suffer any significant traumatic injury. Now, he doesn't say he didn't suffer an injury.
No, but that's, who cares?
But in the, yeah, I get that.
I mean,
I hear you, but in the opinion of
Lots
the...
of cases where plaintiffs suffer injuries, but they're not serious under our law. That's really
You're
the
right.
question before us.
Yeah, and one thing I want to note about, as a doctor writing, my opinion is the plaintiff didn't suffer significant injury, but as New York State law applies to the case, the doctor notes significant limitation in range of motion, which certainly qualifies it as a serious injury.
Okay, we'll look
So-
at that.
Thank you, Your Honor.
Thank you.
Good morning, judges. Stacey Maris of Costello, Cooney, and Fearon for the defendants, respondents, the Wallaces. May it please the court. I don't want to take up too much of your time. For most of it, we'll rely what's on our papers, but I think the Judge Perdato made an excellent point in the fact that plaintiffs are they're not at the level where they have met their prima facie case in order to even rebut it. So, like in their papers, they are conveniently ignoring the fact that the record is filled with references to mild disability, minor injury, degenerative issues, which are not even addressed by plaintiff in his papers or by plaintiff's expert. And he does admit that the expert's opinion was qualitative in nature. And with the qualitative assessment, in the case that he even cites to Moorer, It is noted by this court that the qualitative assessment also needs with it a comparison, an objective comparison to a normal function of that body part, which is lacking here. And so in more...
So we're focusing on paragraph 10, though, of the plaintiff's expert affidavit. Why do you say that that a comparison to kind of what is normal is lacking in the opinion?
So he really just parrots the fact that what's given in the statutory language, that he says he cannot be doing certain activities as compared to what actually would be a person of normal function would be able to do. And so because he does not provide both of those, he hasn't even met his burden in order for the defendants to oppose that sort of objective. And not only that, but to return to Dr. Molinari's report that plaintiff is relying on, it's found that he had a mild disability. Again, it's just going to the fact that this is well established that mild, minor, slight, degenerative changes, which again, this record is full of references to, does not rise to the level of serious injury, let alone warrant the granting of a summary judgment. So unless there are any more questions, we will rely on our papers.
Thank you. James Guida versus Rivera Investigations, Inc.
Good morning, may it please the court. My name is Michael Sullivan, and I represent the defendant, Alex Hodges, in this case. The appeal taken today was from the trial court that found that Mr. Guida was not in the course of employment. We believe and contend that Mr. Hodges certainly was in the course of his employment with Loomis, as was the plaintiff, Mr. Guida. Both men worked for the company. Both men were mandated to be at this recertification class, which was a Sunday. Both men wore their uniforms to the class. Both men were to be paid for the class, although we agree that they were not paid. And quite frankly, we agree with the assertions of the facts of this case together with plaintiff's counsel, and we believe that because of that, this is an issue of law rather than fact. When you look at the case, it's an accidental shooting, and both men were there because it was a condition of their employment with Loomis. They had to be at this class for the recertification. Both were to be paid, as I said. Both were ultimately not paid because the course was canceled. Yeah. So with all that being said, there's certainly that not only Mr. Guida but Mr. Hodges were there for the benefit of their employer, Loomis.
I mean, this wasn't a horseplay case.
Absolutely not, Your Honor.
Okay, and so the question becomes, if there's a violation of any safety rule, is that taken out of the scope of employment? Because that's one of the allegations, that the gun wasn't supposed to be out. He took it out in violation of the rules there.
I don't believe that to be the case, Your Honor. I believe if there was a violation of the rule, it was incidental to the employment and therefore would still fall within the scope. And having met the burden argumentatively, the burden then shifts to the opposing counsel to raise what the law would require to be substantial evidence to establish not in the employment. And the factors include willful and wanton conduct.
Right, and this wasn't a willful.
It was not, Your Honor. It was not anything for the pure benefit of Mr. Hodges. It was completely for the benefit of Loomis. The case law that's cited on the point that analyzes this is completely...
all the case law that's been cited is mostly the horseplay type.
The horseplay cases were cited, but there were also case law that was cited not only by the lower court, but in the briefing of this case, that some conduct is just so far afoul of what the employment relationship is that it can't be within the scope. Schumer was a case of that. There was, et cetera. And therefore, we believe and we contend on behalf of Mr. Hodges that the fact pattern of this case establishes that he in fact was in the course of his employment with Loomis. And I will end, if there's no other questions, one of the important facts was that Mr. Guida elected for and did receive workers' compensation through his employer. And for that, I will rest. Thank you.
Good morning, Your Honors, and may it please the court, Brian Stein on behalf of the plaintiff, James Guida.
So I think you're relying primarily on the fact that there was a prohibition in this classroom on taking out and handling the firearm.
Yes, it was a clear violation of the safety rule established by Rivera Investigations. And any employee from Loomis who goes to that class is also aware of that that's a violation. You're not allowed to take it out. The class hadn't even begun. And just so your honors are aware.
No, but they were there. They were in there.
They were there getting ready.
Right.
But the gun's never taken out in the classroom. It's used later on a firing range.
Right.
But you can't leave a gun in your car, so they have to bring it in. But normally they bring it into a separate room. They clear their guns and put them somewhere else, and then they have the class. But none of that began yet because people were running late. It was a bad morning for traffic, or for winter weather. So the class hadn't begun. They never get paid. And I disagree with counsel that this was not for the benefit of Hodges. This classroom is only for his benefit, going to this class, because he needs to be recertified.
Well, let me ask you this question.
Sure.
A quick side note. I mean, it appears that the plaintiff here, even though it's separate, qualified for workman's comp, meaning they're gainfully employed. They're employed at the time of the injury, correct? So his coworker was there under the same guise, the same everything else. And I thought what would happen, what the argument would be, was that the co-employee, the defendant, so to speak, co-employee, would be also is it also an employee? But what takes this out of that realm is that the conduct of taking the gun out. So you're not arguing that he wasn't an employee like the plaintiff, just that by the gun coming out and violations of the protocol or the rules there, that takes it out of the realm of the workman's comp.
Exactly. And that's the Court of Appeals case of Rivera, name not similar to the Rivera investigations in this case, but that's the Court of Appeals case. You have to go through those litany of questions. How is this possibly in the furtherance of interest of the employer by taking his gun out and accidentally shooting a guy? How can it be said that this specific, how about foreseeability?
Well, let me just backtrack to your last point.
Sure.
I suppose if we take every sort of negligence case and you focus specifically on the negligent conduct, I mean, negligent conduct can never be considered in the furtherance of the employer's interest. So that's not what is the focus. I think is whether the attendance at this firearms training course was in the furtherance of the interest.
And that's what I was getting to before. It's actually in furtherance of his interest. He could have taken this course and the next day quit Loomis as an employee and started working for another armored car guard service. This had nothing to specifically do with Loomis's interest of their employment. This is his. He could then quit and start somewhere else. And also, let's talk about foreseeability.
But he can't work for Loomis without having completed
Loomis
this
is paying for
course.
Loomis would have paid for it if it occurred, but he could have taken it in 5 different locations. He just chose to go to this one. I think foreseeability is a big one here. I agree, Judge Peridotto, that you don't run if you're working for an employer and run a red light and cause an accident, that's not in the furtherance of their interests of their employment. But that is foreseeable. Taking a gun out in a classroom setting where you're never supposed to have a gun out and shooting a co-employee in the leg is certainly not foreseeable by the employer. And that's one of the factors.
Okay, we'll look at all that very carefully.
All right, very good.
Thank you.
Thank you very much, Your Honors. It's nice to be back live in a courtroom. It's been a while.
Charles McLaughlin versus City of Syracuse.
Good afternoon. J.P. Wright with Bond, Shenick and King on behalf of the appellant, City of Syracuse. As stated in our briefs, the decision and order below should be reversed insofar as it denied the city's motion for summary judgment. It's undisputed that Officer Breen was responding to a 911 call at the time of the accident involving an armed suicidal man. Officer Breen had the right-of-way as he traveled north on Teal Ave in the city of Syracuse. There were no traffic control devices or obstructions in front of him. And suddenly, plaintiff Charles McLaughlin decided that he was going to make a left-hand turn across a double yellow line.
Well, you skipped over the fact that there's an issue of fact as to whether Breen was speeding going up to 40 miles an hour.
Yes, Your Honor. Now, the court below found that there was an issue of fact whether he was speeding, and that's why they didn't apply the emergency vehicle doctrine. Our position is plaintiff has not made that an issue of fact. Plaintiff's position since the notice of claim, the complaint, his deposition testimony, his bill of particulars, is that Officer Breen was speeding. That's their case. He was speeding, and he somehow caused the accident due to his excess speed. The issue of fact is between the two officers that were in the vehicle. The driver of the vehicle, Officer Breen, admits, I was traveling between 30 and 45 miles an hour. The speed limit was 30. Officer Breedis, who was riding next to him, says, no, I think he was traveling within the speed limit.
Well, let me ask you a question, just based upon those two things, and it's your burden we brought to motion. How have you met your burden? That he was speeding. You put in a deposition testimony of both both officers in the vehicle. One says I was speeding, and the other one says he wasn't speeding.
Because our position, Your Honor, is the plaintiff has taken the position that he was speeding.
It's your burden.
It was your burden, you're a moving party.
You submitted evidence before us that goes both ways. It contradicts, the two pieces of evidence contradict each other.
And as we said in our papers, Your Honor, they cannot use the speed as a sword and a shield, which is what they're doing here.
But it sounds like you want there to be speeding, because then you get the heightened reckless disregard standard.
Correct.
You fear plaintiff is going to try to show at trial that there was no speeding, because in the absence of speeding, then the negligence standard applies. You're worried about that. Fair?
Our alternative argument, Your Honor, is that if there was no speeding, there's no negligence.
Case is over, right. But there's obviously an issue of fact as to whether there was speeding here. So really what the more difficult question, I think, which is your alternative argument, is let's assume that there was speeding, and therefore the reckless disregard standard applies, because he was obviously driving an emergency vehicle, responding to an emergency. There's no evidence of recklessness here, so the city should win.
Correct.
That's, to me, is the real issue in this case, and that's a close issue.
That's our initial argument.
Really what it comes down to, we have to assume he was going 45 and a 30, viewing the evidence in the light most favorable to the plaintiff. We have to assume he was going 45 and a 30. He didn't have his siren on. He didn't have his lights on. He did have the right of way. So do those factors, and there's some policies that he was violating, he should have done this. So does all that equal recklessness? That's really what we have to decide, right?
If you get to the point where you decide that the emergency vehicle doctrine does apply, because you find that he was speeding as a matter of law, then the analysis is...
And that's what we'd have to do, yes.
The analysis
We have
is,
to
was
get
he
there
reckless?
first. Right.
And you take all that into account, you do not need to have your lights and sirens on under Vehicle and Traffic Law 1104C, as this court has recognized in the Nikovov case, to take advantage of the emergency vehicle doctrine. And in the cases that we cite, especially the Court of Appeals case where the individual was driving down...
Yeah, but Counselor, you may not have to have them on, but the question becomes, is it a factor to be considered?
It's a factor to be considered in the recklessness analysis, yes, Your Honor. And our position is, under these circumstances, assuming you're going to apply the emergency vehicle doctrine, taking everything into account, the fact that the reason
Can I just clarify, you say assuming we're going to apply it. We have to assume that it applies because there's an issue of fact on speeding. Because you agree, if there was speeding, then the reckless disregard standard applies. So there's an issue of fact on that. So looking at it, The only way you win is, let's assume that they're speeding, which you want there to be, you still win, because there's not recklessness.
Correct, Judge. And the alternative argument that we could win on is if there's not speeding, there's no negligence. The plaintiff cannot have it both
We can't say
ways.
as a matter of law that there was not speeding, when we got one officer who said, I was driving as fast as 45 and a 30. We can't say that as a matter of law, even though another officer says there was no speeding. We can't possibly say there was no speeding on this record and then dismiss the case on that ground.
At trial, plaintiff's going to have to argue there was speeding.
No,
That's his case.
They could argue that he was speeding and therefore reckless.
Yeah, we'll look at, I think we have your argument.
Okay.
Thank you.
Thank you, Your Honors.
Roy Harriger versus State of New York.
Good afternoon, Your Honors. May it please the Court. The factual findings of the Court of Claims here require dismissal of the claim under Rivera versus State of New York. Crediting the claimant's testimony in its entirety, the Court of Claims found that the officer escorting claimant to the showers for protective custody attacked him without justification or provocation. Under Rivera, the attack served no legitimate penological interest of the employer. It was not a mere disregard of instructions. It violated statutory prohibitions against inflicting blows on any inmate unless in self-defense or to suppress a revolt or insurrection. Officers are not supposed to use force at all unless they have the superintendent's advance permission to do so, unless there is immediate danger to safety, security, or property.
So you're arguing that he was acting outside the scope of his employment?
Exactly, Your Honor.
But that argument was not made below, right?
That's correct, Your Honor, but it is a matter of subject matter jurisdiction of the court that may be raised at any time. There are two provisions of the Court of Claims Act that make it a subject matter jurisdiction argument. The first is Section 9 of the Court of Claims Act, which is entitled The Jurisdiction and Powers of the Court. 9.2 states that the court has jurisdiction to, quote, hear and determine claims for the torts of the state's officers and employees while acting as such officers and
Doesn't
employees.
9.2 speak more to the status or the capacity as an officer or employee and not the conduct of the officer or employee?
It speaks to respondeat superior liability, Your Honor, as the Court of Appeals recognized in Brown versus State of New York. We also have Court of Claims Act Section 12.1, which states that no judgment shall be granted on any claim against the state except upon such legal evidence as would establish liability against an individual or corporation in a court of law or equity. This reflects the policy that funds will not be paid out of the public fisc on cases where there is legally insufficient evidence of the state's liability.
That's a matter of proof, not subject matter jurisdiction.
Yes, it is, Your Honor. It is. I respectfully disagree. Section 12 is found in Article 2 of the Court of Claims Act. Section 8 of the Court of Claims Act says that the claimant shall comply with the limitations of Article 2 in order to obtain waiver of the state's sovereign immunity. If this claimant doesn't present legally sufficient evidence to support their claim of liability against the state, it impacts the waiver of the state's sovereign immunity.
But when you don't challenge that below, I mean, that seems to be why I first asked the question about preservation. If you had challenged it below, perhaps the proof presented by the plaintiff would have been different.
No, Your Honor. Again, I have to disagree with that. I mean, again, I think that goes to the fact that this is also an issue of law appearing on the face of the record. But I just want to get back to a second to the Section 12, Paragraph 1. If this is a matter of subject matter jurisdiction, then our office, our EAG, her failure to raise it below cannot grant the Court of Claims jurisdiction to grant judgment against the state. So regardless of whether we raised it below, there is an absence of jurisdiction to grant judgment against the state
If it is a matter of subject matter jurisdiction, I don't disagree with that. That's the question, though.
That's what we're going to have to determine that.
Correct, Your Honor. And again, I would point to, I think Section 12.1 is very clear on this. It's just as an individual or a corporate entity is not liable for the torts of an employee that fall outside the scope of their employment, so too the state is liability under circumstances, under the same type of circumstances. So we are presenting the scope of employment argument we acknowledge for the first time on appeal, but that's the burden of claimant. That's section 12.1 that says if it's legally insufficient, no judgment shall be granted. As far as claimant being deprived of an opportunity to present further evidence on the issue, I would point out that in their brief, they didn't cite any evidence that they would present had they been known ahead of time that this was going to be an issue at trial. In fact, they didn't ask about scope of employment and whether or not it was going to be raised as an argument until after the trial had concluded.
Well, wasn't that based upon the state's opening statement where they indicated that wasn't going to be part of their theory of the case?
Well, I point out that this was claimant's entire theory of the case. Claimant had an opening argument first, and claimant's opening argument, they said that they were going to show that the staff members at Attica, without any provocation or legal justification, brutally beat Mr. Harriger. So that was their entire theory of the case. The lack of proof here is not that they would have presented something that could have cured that. The lack of the very theory that they were advancing at trial is one that is insufficient to prove liability against the state, because Rivera says if they've acted without provocation or justification, then liability against the state does not lie under respondeat superior.
Okay, I think we have that argument.
Your Honor, I'd like to address just briefly the Galloway case from the 3rd Department. We argue here that the case is distinguishable for several reasons in our brief, but I'd like to concentrate on 2 here. First, Galloway, there was a different procedural posture than this case. The Court of Claims in that case had granted a motion for 4401, a directed verdict, after having heard all the proof at trial. And the 3rd Department said that was error. The court should have issued factual findings consistent with what it viewed the proof. Here we already have those factual findings. And the factual findings say that Mr. Harriger was the subject of an unprovoked and unjustified attack. Also in Galloway, on the remittal by the Court of Claims, the Court of Claims found that even though the officer initially was acting within the scope of his employment in conducting a pat frisk of the claimant there, once he attacked the claimant, he was acting outside the scope of his employment when he did so, and the claimant had done nothing more than comply with his instructions. The Court of Claims also found that even though it was there was a question of reasonable foreseeability that attack might happen there, that reasonable foreseeability, which consisted of the inmate having filed a claim against the officer under the Prison Rape Elimination Act, that what that showed more for the court was that there was a personal motivation involved in the attack by the correction officer, and that the correction officer was in fact acting without any legitimate penological interest of the state in mind. Here we don't even have a reasonable foreseeability aspect to this claim. The claimant never at any time filed a complaint against any of the officers involved at Attica, even before the attack occurred. So there's nothing to put the state on notice that any of the correction officers were at risk of attacking him without provocation.
What about the behavior in the sergeant's presence?
Well, the behavior in the sergeant's presence...
Or the behavior of the sergeant himself?
Well, the behavior of the sergeant himself, I think, is subject to his own personal liability, which he is being sued by the claimant in the federal courts for having failed to protect him, and also for violating his Eighth Amendment rights.
I believe it's his estate at this point, isn't it?
Pardon?
Isn't it his estate that would be sued at this point?
That's correct, Your Honor. But again, I think that goes, the fact that there's a personal suit against the correction officer that was involved, that's something that Rivera also envisioned, was that there would be personal suits against the correction officers who committed the assault and those who were complicit
Yes, but Rivera,
with
I don't
him.
believe, spoke to the issue of the lack of documentation or identification, meaning that the person who actually committed the assault would remain anonymous, and therefore there'd be no way to address the issue.
It's unfortunate, Your Honor, too.
Unfortunate?
No, if I may, that Harriger, Your Honor, I grant you, our correction officers did not act in any way in how we would expect them to act throughout this case.
Even the judge in the Court of Claims indicated that in her almost 20-year career, she had seen the opposite. She had seen documentation, knowing where every correction officer and every inmate was at any given moment of a day.
Right, which is why I think it's most important to hold Sergeant Dunbar responsible for not having cooperated.
Sergeant Dunbar, the person who, with all that happened here, doesn't seem to know who it was that escorted this inmate from his office?
But again, that shows a complicity in the act of the assault itself, in the fact that he's not cooperating with the investigations that would uncover the person who did it. We also have a situation here, Your Honor, where claimant himself was unable to identify the correction officer who committed the assault against him. And
We understand all that?
Yes.
And so I think, why don't you wrap up?
Yes, Your Honor. Again, we believe this issue is properly before the court, and that under Rivera, the assault against Mr. Herringer was undertaken without provocation or any justification. And under Rivera, that requires dismissal against the state because the correction officers were acting outside the scope of their employment. And I have just one further thing, Your Honor. Again, I think it's important here that there is causes of action that can go forward, at least against with Sergeant Dunbar. Because we want to deter correction officers from engaging in this very type of conduct.
And partly the way that could have been done is if people had cooperated and identified who these different correction officers were and had documented everything they were supposed to document, but I understand that.
We might know more about who is involved, but we do at least have Sergeant Dunbar, and putting the state on the hook for this is not going to change those facts.
Okay,
But we do
understand.
want to
Okay,
be able to
thank you.
deter this conduct in the future by correction officers.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Edward Sivan for the respondent. Putting aside the preservation and related procedural issues, which have been fully briefed in this case, the facts of this case did not require the lower court, sua sponte, to hold as a matter of law that the actions of this anonymous correction officer were outside the scope of his employment. I think we can all agree that there's some clear-cut cases that fall on...
You need to make sure you keep your...
I'm sorry, Your Honor. I think we can all agree there's some clear-cut cases that fall on either side of the spectrum. If a correction officer rapes an inmate, it's outside the scope of his employment. If a correction officer, in defending himself from a physical attack against an inmate, uses excessive force, that's clearly within the scope of the employment. This case falls somewhere in between. But there are a lot of indicia that the act of this officer was within the scope of his employment, and nothing indicating that it was done solely for his personal motives. And that is the test. On orders from his supervising sergeant, this officer was physically escorting Mr. Harriger through the correctional facility, which is an activity which potentially can require some use of force. And in fact, the officer did use some force on Mr. Harriger when Mr. Harriger momentarily deviated from the course. He made a left-hand turn and the officer grabbed him. And once in the office, in front of his sergeant, the officer put Ms. Harriger up against the wall. When Mr. Harriger attempted to look at his name tag and took his head off the wall, the officer, again in the presence of the sergeant, slammed his head against the wall and then announced that if Harriger did something else that he believed was a deviation from his orders, he was going to split his head in 4 pieces. And that's exactly what he did. Now, was that justified? Of course it wasn't. Was it in compliance with DOC's rules and regulations? No. But it was not outside the scope of employment because it was not done for his purely personal motives.
That's what we have to look at.
But, Your Honor, there's another factor that I think weighs heavily in favor of affirmance. The state is attempting to portray this officer as some type of rogue officer who did something that Attica would never in a million years condone. But the OSI determined that one of the reasons we don't know exactly what happened to Mr. Harriger is because of the policies and practices of Attica involving, quote, systemic lack of reporting, documentation, and recollection. I think it's a charitable way of saying a cover-up. And this systemic malfeasance by Attica has prevented all of us from knowing exactly what happened to Mr. Harriger on that day.
And who?
And the state should not be allowed to benefit from that malfeasance by arguing that, Mr. Harriger, there's not enough documentation and you haven't met your burden of proof. Thank you.
Thank you.